If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
All right, so for these hearings, we have an agenda. The first item is the call to order. We handled that. The next item is the pledge of the flag. The next item after the statement is approving the minutes from the March 16th, 2022 hearing. I have a copy of those minutes in front of me. I've reviewed them and have no objections myself. Is anyone here who has comments or objections to the proposed minutes? Hearing and seeing none, I hereby approve the minutes.
Staff update, abated and continued cases is posted out front.
Okay. So for the record, we have an attorney who's called in. I want to explain to him briefly what we're going to do. Is his case going to be first? Or?
His case is the LaVentures LLC case, and there's a pleading he's filed, which I guess he can explain to you.
Okay.
And you have a copy of it.
Okay. I'll allow the case to be called.
Oh, okay, the first case is LaVentures LLC, case number 215-1365. Alan Jonasson is the code officer, page 13 of your agenda.
Mr. Kramer?
Yes, sir.
Good morning. I'm Christian Waugh, the Special Master. How are you doing this morning?
I'm doing good. I appreciate you taking me under this condition with calling in. I appreciate it.
That's all right. First, I want to ask can the county hear Mr. Kramer okay?
Yes.
Mr. Kramer, can you hear me okay?
Yes, sir. I hear you loud and clear.
All right. So your case, or not per se your case, but the case has just been called, and normally what I do is I allow the county to present its case first after appearances are made on the record. But first, I'd like to ask you to make your appearance and tell me who you're here for.
Yes, sir. So my name is Terry Kramer. I'm an attorney for my client is LaVentures LLC, and I'm here on case number 215-1365, dealing with an address of 3769 East Orchard Street, Hernando County, Florida 34442.
Thank you, sir. And my understanding is that you filed a pleading in a related case?
So if I may, briefly I'll explain.
Yeah.
The code enforcement violation that I guess we're here for today deals with like junk debris and like storing a multitude of things on my client's property. We found out that my client, he's in the northeast area. He's not in the area. These are just lots that a adjacent neighbor or one of their tenants has, I guess, taken over this property and is storing all this junk debris, abandoned vehicles, and actually built a fence around the property and locked it. So I filed a lawsuit to try to, my concern was to, in order to have my client to be responsible if we remove all this stuff and throw it out, if it's somebody else's property. So that, and among other things, to prevent them from anyway to my property. So I filed a lawsuit on Monday against an adjoining property owner. There's actually 3 owners of the property.
Okay, I see what's going on. Mr. Kramer, I think what I need to do is I need to hear from the county, and I want to make sure that you'll be able to hear what they say. So, Mr. Jonasson?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Alan Jonasson, Citrus County Code Compliance Officer.
No, Mr. Jonasson, I just want to ask you to pause. Mr. Kramer,
Sure.
Can you hear Mr. Jonasson?
Yes, I can hear him.
All right, go ahead.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 215-1365, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 3769 East Orchid Street, Hernando, Florida. Property owner is LaVentures LLC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 24 September 2021. Photos taken during a compliance inspection on 7 January 2022. And photos of my final inspection conducted on 19 April 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the certified mail receipt, and a copy of the SunBiz paperwork.
First, Mr. Jennison, I want to ask if you've had any conversations with LaVentures LLC or the attorney for LaVentures.
I have not. I was directed by the Citrus County Code Compliance Director Scott McKinney to cease conversation because they had contacted an attorney and we referred them to Beth Antrim.
Well, you said cease communication, so have you had communication
I had
with LaVentures?
communication initially with Michelle,
Okay.
who I think is a realtor, but I'm not for sure. And then as soon as she said they contacted an attorney, we ceased engaging with them.
Okay. Ms. Antrim, have you had any contact with Mr. Kramer or anyone on behalf of LaVentures?
Yes, Mr. Kramer and I have emailed each other. He was requesting that today's hearing be continued. He had previously requested a continuance and Mr. McKinney granted it. I told him I didn't have the authority to grant a continuance, but that we would have him appear by phone today and he could request that.
Okay, and Mr. Kramer, that is something I was going to ask you. It seemed like you were implying that you might request a continuance, but perhaps I didn't give you an opportunity to do that. Is it your desire on behalf of your client to request a continuance of this hearing?
Yes, Your Honor. If you would take that under consideration, I would like a little bit of time so that I can get these defendants served and figure out how to fix this problem for everyone.
Here's what I'm going to do. I'll do two things. One, I have a copy of a complaint and demand for jury trial in front of me filed in Citrus County, Florida. It's filed ostensibly by you on behalf of LaVentures LLC against Yvonne Revels, Alan Campbell, and Donna Sweet. Are you familiar with that complaint?
Yes, Your Honor. I filed this complaint.
I'm going to make this a part of the record and admit it as Respondent's Exhibit A. And on that basis and on the basis of your motion, I'm going to continue the hearing 60 days or 2 months to the June hearing.
Yeah, June 16th.
Okay. Mr. Kramer, the only thing I would say is that in the Citrus County Code, owners still remain responsible for the, what's present on the property. So I would just keep that in mind as we prepare for the June hearing. Do you have any questions or concerns?
No, Your Honor. Thank you, and I appreciate your time.
Does the county have any objection to what I've done?
No, sir.
Okay.
No, Your Honor.
All right. Thank you, Mr. Kramer.
All right, have a good day.
Bye.
Next case on the agenda is Jert L. Hamill, case number 215-3458, Code Officer Alan Jonason. And we have Mr. Hamill's attorney, Joe Schumacher.
Good morning.
Good morning, Mr. Long. How are you doing?
I'm good. How are you?
Mr. Hamill, can I swear you in, please? I need to swear you
Raise
in.
your right hand.
Yes, right hand.
Okay.
Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 215-3458, Protection and Use of Rights of Way, Section 7320A of the Citrus County Land Development Code. The address is 7216 North Whippoorwill Terrace, Hernando, Florida. Property owner is Hamel. I apologize if I said that wrong. Jert L. I have good service via fine appeal email request from the property owner's attorney. This is a fine appeal case from a case which is initially heard on 19 January 2022. On 1920.
Mr. Johnson, let me stop you.
Go
Let me
ahead.
stop you. I realize that I haven't given my opening statement yet.
I apologize.
And this is for the benefit of all people who are here. There's no harm, no foul that we missed it for the hearing being continued. But I just want to make sure I put everything on the record for everybody else, if you don't mind.
No worries.
Okay. Sorry, I rushed in here a little late, so I wanted to get started. Good morning, everybody. Again, my name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that today Citrus County has hired me to preside over your hearing. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation against you and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence as you wish. During this process, the county attorney's office or myself may have questions of you, other parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case, made as succinctly as possible, and it is not an appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all real or personal property that you own, and the county may foreclose on the lien or seek money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county code. The county will continue filing liens against your property until you notify the county of your compliance. In all cases in which I do find someone guilty of a violation, I will impose all costs required by county ordinance or regulation. If you abate or fix the violation in the time allotted, that cost will remain minimal. If you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between hearings, I will require that you comply with the county and its code in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. I don't think there's any appeal from an order to demolish, repair, secure today. Ladies and gentlemen, you do have the right to appeal any order that I make today as may be provided by law. Thank you for your patience. I'd now like to return to case number 215-3458.
Would you like me to start over or just
Yes,
continue?
please.
Okay, absolutely. Alan Jonason, Citrus County Code Compliance Officer. This is case number 215-3458, Protection and Use of Rights of Way, Section 7320A of the Citrus County Land Development Code. The address is 7216 North Whippoorwill Terrace, Hernando, Florida. Property owner is Hamel Jert L. I have good service via fine appeal email request from the property owner's attorney. This is a fine appeal from a case which was initially heard on 19 January 2022. On 19 January 2022, in a special master hearing, respondent was found guilty and granted 30 days to abate the violation. If the violation was not abated, a penalty of $150 per day was recommended. However, that fine was increased to $350 per day by the special master due to the property owner's actions and statements made to the Code Compliance Director, Scott McKinney. An inspection conducted on 21 February 2022 revealed that the violation had not abated. A copy of the order imposing fine in the amount of $350 a day beginning on February 24th, 2022, plus administrative costs of $359.72 was sent via first-class mail advising of the 20-day deadline to request a fine appeal. On 16 March 2022, the respondent's attorney requested an appeal via email. An inspection on 19 April 2022 revealed that the obstruction of the right-of-way violation was abated.
And Mr. Johnson, did you say you had any proposed exhibits for opposing counsel, or
I have 3 exhibits.
what are those exhibits?
Exhibit A, I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, a copy of the findings of fact, conclusions of law and order from the 19 January 2022 hearing, a copy of the first order imposing fine, and photos from Exhibit A from the 19 January 2022 hearing. Exhibit B, photos taken of my final inspection conducted on 19 April 2022, And Exhibit C, a copy of the email requesting the fine appeal from the property owner's attorney, Mr. Joseph Shoemaker.
All right. For the record, Ms. Spiros, we just had another call coming in. I'm not sure if you're expecting other calls or. Okay. All right. Mr. Shoemaker? Is it Shoemaker or Schumacher?
Shoemaker.
Shoemaker. I'm sorry.
I know I met you, Mr. Wall, but just by phone.
I was going to say I didn't know if you were the same Shoemaker who I've spoken with by the phone.
Marshall.
Gotcha.
So, yeah.
Very good. Let me just ask you if you've had a chance to review what Mr. Jonathan just identified
I
already.
have not, but we have no objection, Your Honor.
Oh, you don't? Okay. Then, just so you know, what I normally do is I allow the county to present whatever it's doing, and then I go to you and I ask you.
I've done these in some other counties, not Port City.
Sometimes there's different procedures, so I just wanted you to know. Go easy on me today if you can. Thank you. Is there anyone from the public who wishes to be heard on this case? Okay, then not having heard any objection from Mr. Shoemaker. Oh, I'm sorry. Okay, all right. Thank you, ma'am. I appreciate that. Do you have any? You're going to want to make public comment?
Yes.
All right. Thank you. Having heard no objection from opposing counsel, I'll admit what's been proposed as exhibits A, B, and C for the purposes of this hearing. Is that the conclusion of your testimony, Mr. Johnson?
Yes, sir.
All right, Mr. Shoemaker, I'd love to hear from you.
Yes. Your Honor, I met with my client, Mr. Hamill. Again, I've not been to Citrus County before. We certainly appreciate you spending time here today. Explained to him that there was already a violation, there was already an order imposing a fine, and at this stage, the goal in most counties and most cities that do this obviously is to get compliance, and we need to get compliance. Now, I instruct him to go out and get a survey, of the property and to take whatever actions are going to be necessary to abate this, again, this violation regarding the berm, if you will, on his property. And I have photographs, because I wasn't certain if the county had already done a reinspection. We believe they had, but we wanted to make certain that we had photographs showing that he has, in fact, abated the violations. Ms. Antrim of the county was polite enough to certainly give us some direction on what they believed needed to be done, and we believe that that's been done today. And I have photographs of both the two streets, Whippoorwill and Silverthorne, adjacent to my client's property, and photographs showing that he's moved back this berm at least 25 feet on Silverthorne, which is what's required from the center of the road, as well as 30 feet on Whippoorwill, which is also required. And again, he's done so at this stage. Obviously, it's within the court's discretion, because there's already been a fine imposed on his case. But again, we would ask if the court has any ability to address the fine at this stage, because my client is in compliance, and the goal is to keep him in compliance. He may eventually sell this property, but that's not for the court today. But it needs to stay in compliance.
Does the county have a position on the relief being requested by Mr. Hamill?
If he's in compliance, then you have the authority to grant the request.
So at the time of a fine appeal, assuming that the violation is brought into compliance, I have the authority to vacate and repeal the fine? Is that what?
It hasn't been recorded, correct? Yes, it wasn't recorded, so.
Oh, there's no order imposing a fine?
It hasn't been recorded.
Because he
We appealed
filed
the fine.
an appeal.
I
If you
see.
file the appeal before it's recorded,
So-
then you have the authority to.
My
remove them of the
understanding, I thought, and we've discussed this, so I just need a little help on the briefing, is that normally on a fine appeal, my discretion is limited to whether or not the fine has been calculated correctly. But you're saying that that's not the case if it hasn't been recorded yet.
I think he's correct that he just has the authority to make sure that the fine was calculated correctly.
Well, why don't we check the code on this?
You can't they can't appeal the factual basis for the fine. They can appeal the amount.
Yeah, and I think throughout the state, the government entity reserves the right to address whether or not, in fact, I'm going to go to St. Cloud later today where they've already agreed to abate the fine in our case. But it's certainly within the discretion of the government agency.
Yeah, I just want to check the code and see what it says. I know that sounds crazy, but I tend to like to do that. When I appear in front of a judge or a special magistrate, I certainly never tell them that they don't have the authority to do something because they don't like hearing that. But I actually believe that officials are limited in their power, so I just want to see what the code says.
And I believe you're right. I think I was misstating what it was, that you can only look at to determine if it was calculated properly.
Okay.
I was more focused on whether it had been abated, because usually they haven't been abated by the time they.
Right, and of course, the county is mostly concerned with compliance, so I just want to see, let me just look at this here. I found the regular section dealing with appeals, which is 19-56, but I know there's a specific fine appeals section. I apologize for the delay. Also, for members of the public, these hearings are filmed and they ultimately air on YouTube. So I would be mindful of that. And obviously, me looking through the code section is not riveting YouTube watching, but it is available. Does the county know where the fine appeal?
I am actually trying to find it myself.
Yeah.
I think it has something, it's in the special master's
Yes, probably.
portion of it, not the actual fine appeal or the appeal portion.
Is that in chapters? Let's see.
I find it online quicker than I can find it in my book.
Is that in the Citrus County Code?
Mm-hmm.
Okay. Mr. Shoemaker, are you familiar with the, Citrus County Code, or are you aware of the fine appeal section?
We reviewed it briefly, Your Honor,
Okay.
but I don't know what it specifically says regarding the
Okay.
process. I'm just aware there's Attorney General opinions, but I didn't bring with me today. And I can tell you it's a common practice throughout Florida that, again, if there's a compliance, then there's some discretion, even after the fine is recorded. In fact, that's literally what I'm doing today in St. Cloud. Is we had a fellow that this was a violation from several years back. We have $40,000 or $50,000 fine that we're going to, again, have reduced through the process. And my client's going to be in compliance. And generally, that's the goal, obviously, of any county or city, is to make sure that their citizenry is following these rules and not to necessarily wind up taking their properties. But if they don't comply, then that's one of the remedies. You can get a lien, you can lose your property, and again, that may certainly occur if they don't comply, but certainly spoke to my client about that process. He understands, and we are in compliance today and has taken all the steps necessary to make sure that, again, he's going to stay in compliance. And he isn't, based on what the county has said, that is in fact the case.
I agree with everything you've said. I mean, my one concern is what the code says about the authority, and you know, I'm surprised that we can't find the code section.
We just have to look it up on Muni Code.
Yeah, that's what I'm trying. I have it tabbed in my other book. It's not tabbed in this one. So that's why I'm trying to find it.
Because I've seen it several times.
Take a comment from the public?
Yeah, sure. If the little amicus brief, if you know where the code section is.
So, no, but if you just go to Citrus County's web page under Special Master Hearing Meetings,
Yeah.
there's a brief description on what the Special Master can and cannot do. And it speaks to Florida State Chapter 162 as amended
Yeah.
from time to time. Powers conferred upon local governments therein, including but not limited to the authority to execute satisfactions and releases of liens.
Chapter 160, for the record, you are Mr. Kyle Breeden, a member of the public. Can you confirm that for the record?
Yes, sir.
Okay. And that is helpful. I think Chapter 162 is kind of incorporated in terms of what powers the special master has in Citrus County. So I will look at Chapter 162. I'm really hesitant to issue an order until I
Can
see
we
the.
just continue this hearing for, if it's not, can we continue this hearing for a few minutes?
Oh, I can put it in a recess and take
Yeah.
something else up.
That's what I was.
Okay,
gonna
Mr.
say.
Shoemaker, that's what I'm going to do. Time is 9:33. I'm going to put this hearing into recess. We'll take another hearing up so we don't waste any more time until we can find that code section. Thanks.
The next case, Liquid Communications, Inc., case number 215-0842, Code Officer George Pearson, page 14 of your agenda.
Good morning.
Good morning.
Mr. Smith? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Oh, I'm sorry. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Morning.
Morning, Mr. Wall. You ready for me?
Always.
Okay. My name is, for the record, my name is George Pearson. I'm the Citrus County Code Compliance Officer. The violation is, the case number is 215-0842, storage on a vacant parcel, a violation of Citrus County Land Development Code 2412 and 2406. The address of the property is 3577 East Kirby Lane, Inverness, Florida 34452. The property owner is Liquid Communications Incorporated. Service was made good by posting of the property and posting of the bulletin board dedicated to such postings at the Lacanza Government Center. And I would like to authenticate and request the following be entered into evidence. Exhibit A, photographs that I took on September 16th. The photographs depict the violation of a storage on a vacant property. Exhibit B, copies of notice of violation, notice of hearing, affidavit of posting, and property appraiser report. Exhibit C, photographs that I took on April 19th, 2022. Photographs, the property was still in violation.
I'm sorry, Mr. Pearson. Were those proposed exhibits A and B? Was
A,
there
B, and
And
C.
C? Okay.
I'm sorry.
No, that's okay. So it was photos, and then as Exhibit A, procedural documents as to Exhibit B, and then Exhibit C were follow-up photos, I believe.
Were follow-up photographs taken yesterday?
Let me, Mr. Grant, you're familiar with how I normally conduct these hearings. I'd like to ask you to take a look at, have you seen what's been proposed as Exhibits A, B, and C?
No, but we're not going to object either.
Okay.
I don't have 8 hours.
Okay.
Yeah.
All right. Then without objection, what's been proposed as Exhibits A, B, and C are evidence.
Where's the pictures?
I can't hear what Mr. Pearson's saying.
He's not on the record.
I'm sorry, we're not on the record in here?
We are on
He
the
was
record.
talking to me, he wasn't talking to, he wasn't on the record.
Okay. Let's see. All right. So, Mr. Pearson, proceed.
I conducted an initial inspection on September 16th, 2021. A violation of storage on a vacant parcel was observed. Large rolls of communication wire are being stored on a vacant parcel. I spoke with the subject who identified himself as the owner of the property, Mr. Chris Smith. He stated that the property was zoned commercial and that he felt he could store them there. The property is zoned both commercial and medium density residential. 2 notice violations were issued because of the address owners have changed. 2 amended
I'm
notices.
sorry, Mr. Pearson. I didn't.
2 notices of violation were issued because of the address that has changed. Initially, it was Damon Street or something like that, which the property appraiser had, and then it was a P.O. box.
All right. So, before you continue, let me just look briefly through these.
We're not going to take any exception to that.
Okay. I want to understand.
Can I clarify?
No, just give me.
The address was actually misspelled. That was it.
Well, just give me one moment to look through the documents. Sometimes it's helpful for me to get familiar with the evidence. I know that also sounds crazy.
We prefer you don't review it.
Sorry, it's my AFib.
I just asked him to talk louder, you're fine.
I mean, the notices of violation are different than more than just the P.O. box. They're different in terms of the violation that's stated. They're different in terms of the corrective action required. So, I guess what I'd like to...
Well, on the property that's zoned commercial, that's been determined that's where most of the property was, it has to be removed, but
Now, here's what I want to know first, Mr. Pearson. So, there's 2 notices of violation I have in Exhibit B. They're for 2 different code sections. They require 2 different solutions, but I was originally told that the only difference was an address. So I'm wondering, is the county claiming that there's 2 different violations on the property?
no, there's 1 violation on the property,
Okay.
but the property is zoned and it's cut in 2, and it's zoned both ways. I was not sure of which one it was,
Okay.
so I was told to use both violations.
So what you're telling me is there's basically 1 address for the property, which is 3577 East Kirby, but it's got 2 different types of zoning
Yeah.
on that parcel.
Yes.
Yes, sir.
All right, and because of that, there's 2 different violations based on the different zoning.
Well, I did it to cover both violations in case the property was in the residential section.
So you've pled it like in the alternative is what you're trying
Yes.
to... Okay.
But since
Well, this is a first.
then, the director of land development has gone out and she made a determination that the property was sitting on the commercial section.
Okay. And therefore, Which code section are you proceeding under?
2412.
All right, thank you. That's all. Please
And,
proceed.
and under 2412, the property would have to still be removed, and a conditional permit would have to be applied.
I now understand. I appreciate it.
Okay. On December 10th, an inspection was conducted and found that the items were still being stored. A notice of hearing was issued. On January the 19th, 2022, the property was still in violation with the property on the GNC, or the commercial section of the property. Keep in mind that this case has been extended once by you at the request of Mr. Scott, who's requested assistance in obtaining legal counsel, and once by Mr. Grant, who requested through an email of my former supervisor, Mr. Scott McKinney, with the stipulation that the property would be cleared.
Mr. Grant, have you entered an appearance, or would you like to state it for the record?
Yes, this is William Grant on behalf of Liquid Communications. I take no issue with what Mr. Pearson said. I'm going to seek a 30-day continuance. We have taken much of the property off. I know I have the picture. It was done late last night, but for the tires on the trailer having to be fixed because of a necessity of the tire, it would all be gone. So we don't take any issues here today. I ask for the very next hearing date. It will be totally abated. It will be cleared. I don't need to get into, I've corresponded. I appreciate the government's continuance of the past. I just asked for 30 days, and it will be 100% abated. I'm going to show you, this is the photo after the one you took yesterday, where it shows most of the stuff was removed.
Okay.
Okay? I'm going to show that.
Yeah, please. Are you proposing to enter this into evidence?
I am,
Okay.
yes. As soon as she looks at it, I'll.
Sure.
RA is responding A.
Great.
Thank you.
All right. What's been proposed as respondents A is evidence.
Thank you. So just to show that there was a good faith effort to remove much of the property, and it was, and but for as soon as that tire comes in, it'll go on the trailer, and the orange spool you see will be removed. So I asked for a 30-day continuance, and when we come back here, it'll be abated. And I'll notify Mr. Pearson and I'll notify the government's lawyer, and they can make arrangements for George to go back out.
First, I'd like to hear if there's anyone else from the county wishes to testify. I apologize. I believe the county has other witnesses.
We admit.
Right.
You admit, okay.
Yeah, I don't see.
I don't think
You
there's.
concede.
It's not necessary. So if you give me a
Well, it
continuance.
might be. I mean, and so I just want to always lay the record. What I'll
I
do.
want to hear it loud and clear from Mr. Grant.
It is what it is.
First time for everything. Yeah.
And YouTube.
And so,
Yeah.
but no, it needs to be moved. There's no dispute. I just asked for 30 days so we can abate and get into compliance and comply with the county's LDC.
What I will do is, like I said in the opening statement, there are situations where someone is guilty of violation. We grant a continuance, and that's what we're going to do. So it's uncontested that the property is in violation.
Yes.
And that the respondent is guilty, but I will allow a 30-day continuance, or at least a continuance to the May hearing. I don't know if that's 30 days or not. And we'll take it up May 18th, and we'll take it up
Say it
again.
again, please.
May 18th.
And we'll take it up again then.
Yes. And I will, I spoke to Mr. Pearson before the meeting today. And so my point is that I will contact the government's lawyer and let them know that it's ready to be re-inspected and it's been abated.
Is that okay with the county?
Yes, Your Honor.
Okay. Thank you, Mr. Grant.
So let me make sure. So once it's abated, do I need to come back here again on May 18th?
Well,
I mean,
no.
I enjoy seeing everyone.
Normally what happens is the county will tell me, or it'll be abated and it's off the hearing docket. So,
Do I get confirmation of that? Yes. Okay, very
Okay.
good.
thanks so much. Always good seeing you.
Yes, thank you.
All right.
And with that, may I be excused?
Yes, sir.
Thank you. Thank you, George. I'll be in touch.
If someone has the code section
I think it's
ready.
actually an administrative regulation,
Oh,
and so now I'm trying,
okay.
Then let's just go to the next one.
The next case will be Kyle D. Breeden and Mallory R. Breeden, case number 2144283, Code Officer J.C. Charlton. The expert is Joanna Coutu, and it is page 5 of your agenda.
Sorry.
Easiest way to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning.
Good morning.
J.C. Charlton, Code Compliance Officer. This is case number 2144283, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code 3102A. This case was continued at the March 16th of 2022 hearing until today's hearing. The address is 8646 West Admiralburg Lane, Crystal River, Florida. Property owners Mallory R. and Kyle D. Breeden. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on June 29th of 2021. Follow-up inspections on August 3rd of 21, August 23rd of 21, October 6th of 2021, January 18th of 2022, and my final inspection on April 19th of 2022. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the property appraiser's report listing the property as vacant, and an aerial photo of the surrounding properties.
Well, let me ask, has the evidentiary record changed at all since the last hearing? In other words, does the county wish to introduce any other evidence that it hasn't already presented?
yes, we'd like to enter evidence regarding the neighborhood,
Right, I have an aerial photo of
characteristics of the neighborhood.
Okay.
the surrounding.
And which exhibit is that?
That would be that would be Exhibit B,
What is your...
page 4.
Okay, page 4 of Exhibit B.
Yes, sir.
And I'm sorry, what's your Exhibit A again?
Exhibit A was photos from the initial inspection and follow-up inspections.
And these have already been introduced.
Did we introduce these?
It won't necessarily matter.
Yes,
we'll go
we-
through them
we've
one by
already
one.
More
introduced
recent than the last hearing?
Yeah, do they have any new photos?
No, only new one is the April 19th.
Well, that's
photo.
new.
That's
That's
yes,
new.
yes.
So, okay. And is there an Exhibit C or is it just A and B?
No Exhibit C.
All right, Mr. Breen, we're going to go through the textbook procedure on this, and I'd like to ask you to review what's been proposed as Exhibits A and B, and let me know if you have any objection. I don't know if this is going to change anything, but we'll go through it.
The new stuff on the spot. So I do object to the county's new photo.
And what's the basis of the
The
objection?
basis of the objection is the county's new photo only shows the one parcel. I provided at my first hearing, as well as in an email to you and the county's attorney, a photo of our Farm Service Agency farm tract, which includes 10.76 acres. The county deliberately did not include the rest of our property in this photo. And then additionally, the rural zoning ends at this paved road here. The property to the north of it is zoned differently than rural. We own half of the rural property there. We own the entire city block, half of the next block, and half of the other block.
Let me explain, Mr. Breen. So,
Those properties are not part of this.
well,
Right.
let me explain.
So it is my position that they are.
And I want you to be able to place that on the record. I'm familiar with your argument. I read your brief in full, and I also read your email, and we're going to make that a part of the record. So, in other words, I think you stated one of your positions is you don't know why the county keeps saying it's 0.67 acres because, in fact, you've got, 10 or 11?
I do, and a piece
Acres.
of that deeded property, so I have 3 deeds for all of this property.
Right.
A piece of that property is split by a paved road. The county has no issue with properties being deeded on one deed, split by a paved road. But it has not been addressed by the county at all, where the code addresses that, and so I continue to bring that up. My objection to this photo is that the county zoomed it in on this one property.
Yes.
All of the rest of the surrounding property right next to it is vacant and owned by me. So the photo should include the surrounding area, not 5 houses in my corner lot.
So I think the way normally normally this kind of argument would be an argument towards the merits, and we just automatically introduce the evidence and let the parties argue about it, because you're not making an argument about authenticity. In other words, you're not saying this is fake. You're just saying it's a slice and therefore not as relevant as it could be. But really, in the rules of evidence, what you're making is a completeness argument, and you're saying you really shouldn't consider this unless you see the whole thing. And in a quasi-judicial proceeding like this, those kinds of rules are relaxed, and you still get to make those kinds of arguments, assuming I'm not stupid and I can understand what you're saying about the document, and then I make a judgment call about whether or not I agree. So what I'm going to do is I'm going to overrule the objection as to that document, but I will want to hear your argument, and I'll want to go through what you're saying about it. Now, you also have a new photo in there that's apparently dated April 19th. Do you have an objection to that? It's in Exhibit A.
So there is a, yeah, no, okay, I got you. You just mixed them up, I got you. That's why you threw me off. I'm like, wait a minute, there's more than, all good.
Okay. Then I'll allow Exhibits A and B as evidence on behalf of the county. I'm not going to make it an exhibit, but I'm going to incorporate the county's brief into the record. I issued a briefing order after the last hearing asking both sides to brief me on certain issues. Both sides timely delivered a brief that addressed my questions. And I only have one question based on the briefs, but we'll get into that. Thank you. First, I'm going to look at the aerial that's the subject of contention. This is page 4 of Exhibit B that's the objected to?
Yes.
Okay. Okay. So on page 4, Mr. Breeden, I think what you're saying is you own everything that's in that red line, but the photo doesn't show everything inside the red line.
No, so south of that red line, I own the entire city block from paved road to paved road. I own the next south block. I own half of that block. And then to the north of that red square, the entire bottom of the rest of that block, we own all that as well. So it's only those 4 houses that we don't own.
I see. Okay. What other argument does the county, and Ms. Antrim, I don't know if you heard, I incorporated your brief into the record. I incorporated Mr. Breeden's brief into the record. They're not exhibits, but just for the record. And I actually want to make sure, Mr. Breeden, you had a separate email that because this is a quasi-judicial proceeding where we need to put all these communications on the record. I think last Wednesday you sent an email to the county but copied me. Do you recall that?
Yes, sir. I did it for a reason. We'll get to that.
Well, does anyone have a copy of that? Or
I don't have a copy of it.
You should have a copy of it.
well, I have a copy. Look, I have a digital copy, and what I'm
I
gonna
have it on my computer.
Oh, I got it.
what I'm going to do is I'm going to request that a printed copy of it or a digital copy of it be entered into the record, because it represents a communication outside of the hearing that I think needs to be incorporated into the record. It is not something that needs to be responded to unless the county feels that it needs to respond. I'm not going to ask for a response, but I think it has to be in the record. Is there any other argument that the county wishes to make? about this? That it hasn't already made the evidence and arguments of which I'll incorporate from the 2 previous hearings?
I would just like to respond to the 10-acre argument.
Okay.
This violation is on 3 lots that are in an established block that has mobile homes on the lots and across the street from it. This is not an agricultural area that that's trying to be preserved. It's an existing subdivision with homes. And the 10 acres, the additional property he owns are separated from this property by lots and a road. So they're not part of, you can't look at those additional properties to come up with an acre or more. We're talking about 3 separate lots.
There's also a question in the email, where does the county define pasture? And I think that question arises from the fact that in this zoning, there's an agricultural use that is permitted, which is pastoral lands, I believe. Is that incorrect?
Yes, and I think I addressed that in the brief, that they would have to have established a residence with a pasture. There's no residence there.
So I also admitted into evidence in my first hearing that I can provide a lease for an adjoining residence, just like that.
Yeah, right. Well, actually, can you explain that? You're saying that you can provide a lease?
Absolutely. I can provide a lease for an adjoining residence, i.e. signed notarized lease that says I rent this residence that adjoins the property.
Are you saying there is a residence on the property in question?
No, there's an adjoining property.
Okay, I mean that's...
So it comes back to having been through this before, it comes back to what the code says about adjoining parcels, i.e. the state does not make a determination that a road cannot separate tracts of land to be considered one property. I.e. so this property being arm's reach to my 8 point whatever acre
do you own the road? Do you own the road?
So technically we do, because the county doesn't service it, and it's because the reason I can't make the county come in, and so there's could be additional roads in my property. The county has chosen to dig those into ditches to use my property essentially as stormwater drainage. So they have 7-foot deep ditches that run across my property. They're vacated roads, which by the law means I own the road, or to the center line of the road. Because I own both sides of the road.
So wait a second.
There's no evidence these roads are vacated, and those roads are necessary for other people to get to their properties.
No, so there's only one road that's serviceable. There's only 2.
Let's hold on. So I'm interested in this vacated road. There isn't any evidence of it, but are you telling me that the only thing separating this parcel from your other parcels are roads vacated by the county?
So that parcel is separated by a paved road that's not complete. It doesn't run all the way through. It stops. So there's only 2 residents on that road and our property. The other side of that road, the bottom of the block, the entire north part of that same block, we own. There's no road there. The county has dug 7-foot deep ditches to let the stormwater come off the road and flood throughout our property.
Let me walk you through. So what it appears to me is that, and I want to know if it's wrong.
That's why I wanted a picture of, if the county's going to submit a picture.
If you don't mind, Ms. Reed, just let me speak, and I'll ask. I welcome your comment if I get a chance to speak. So it appears that there are roads that include Lindbergh Drive, Admiral Byrd Lane, and General Chenault Lane, where, I mean, they look serviceable to me. Are these roads not at issue?
You're talking about the roads that go around the property. Those are roads, absolutely. What I'm talking about is General Chenault Lane or Drive.
Yeah, General Chenault Lane.
Which does not go all the way through.
It doesn't go all the way through.
Ends right there into the back side of our property. There's 2 homes on that road.
Right. Can you, okay. All right. So,
if you drove down that road, you would see that there's stuff growing this high right on the edge of the blacktop. It doesn't get mowed. It doesn't anything, right? So there's 0
but is that
maintenance.
a vacated road?
No, when I mention vacated roads, I'm talking about the bottom half of General Chenal. In other words, it doesn't go through the backside of it.
Right, okay.
I'm talking about all of the
That helps
platted
me.
roads within our land that are ditches, right? They're not
All right.
roads.
That makes sense. I don't think that's a dispositive point for this because the applicable roads here are not vacated, and the county is making a statement about this piece of property. But what I want to, and in the matter of the briefing, the issue, and I'm going to pull up the county brief just so that I have it. Let's see.
I have a paper copy if you want that, that'd be great.
I would love a paper copy.
You want one?
Yeah.
We both have one.
Thank you.
Easier than a phone.
Yes.
Mr. Breen, do you have a paper copy of your brief per chance? I have it on my phone, but
I did not bring
okay, that's okay.
Do you
Um,
want a copy of?
I would love it, yeah.
Actually, I think that's
Because I'd like to refer to both of them. I think they are, for the record, I thought it was excellent briefing by both sides, and I appreciated it. They really highlighted the issues for me. But on the issue of the 1 acre versus 10 acres, 10 plus, I found, let's see. The argument that the county presented is on page 8 of the brief, saying even if respondents' property was an acre, and I'll put in brackets, or more in size, under the provisions of section 4680C, animals kept on the property had to be kept as part of a bona fide agricultural operation with proof of the Greenbelt exemption or for the sole use and enjoyment of the residents of the property on which such animals are raised or kept. And I think what the county's getting at is if that is going to be permitted in this zoning, they have to be basically pets for the people who are living there and not raised for commercial purposes or any other purpose. And before I get to, I mean, is that what the argument from the county is?
No, sir. What?
No, Mr. Breen. No offense.
You're right.
I'm always happy to hear from you, but I'd like to hear from the county on this. Am I
First,
misstating?
I don't think goats are allowed as pets, but that's basically one of the points is these. And I'm still looking for I found the AR for the other case, so let me get out of that mindset and get to the brief, if you don't mind.
Could I make a comment, sir?
And
If
Ms.
you don't mind,
Spiros,
just-
I sent that as an email, if that could be printed and brought in.
Absolutely.
I just want to make sure I'm understanding the county's point, and if I'm not, I need to know before we move
They
on.
would have to establish a residence on that property, was part of the argument, if they were their pets.
Yeah, right. I understand, but is the only way to satisfy this quote for the sole use and enjoyment of the residents of the property is that you have to have a residence on the
Right.
property because you
They
can't have residents.
to establish a residence on the property, and
Okay.
there's no residence on either of the any of the three parcels.
One of the points he's trying to make is that, now this is something I'm going to want to hear from you, Mr. Breeden, is there other property that's contiguous to this property?
No,
That he owns? Or
no.
Okay. So in other words, it's the county's position that the respondents will not be able to establish a residence on this property because there is no residence either on this 0.67 acre parcel or on a contiguous parcel.
There's no residence on any of the three parcels, and I don't believe there's a residence on their other land that they own.
Mr. Breen, I do want to
But
hear you on
I
this
don't know
point.
that for a fact.
Right, Mr.
because
Breeden,
that property's
what's
not
the
an
evidence on this point?
So I would go back to the county's point. I interpret the code differently. I interpret the code exactly as she laid out in her brief, which is the part you were reading, which is where she's saying for the to use it as a pasture, we would have to have an agricultural exemption, which is a greenbelt exemption. So I interpret her brief to clearly say that, which is what you were asking about.
I wasn't, but that was going to be my next question. So let's go to that. So the only actual question I had after reading the briefs was about this agricultural exemption. Because what the county, I think what the county's saying is that if the property appraiser did find that the property was being used for a bona fide agricultural purpose, that the county would, that either that would abate the violation or the county would drop the case. Is that an incorrect statement of the county's position?
That's not a statement that was made in the brief.
It is not, but
Because I said it's going to be a policy decision.
I don't
make the policy decisions.
Okay.
You wanted a legal position.
I did, and I wanted to know what you meant by policy decision.
That'll be a policy decision that's made by the administration of the county. This property, though, however, under the law of what constitutes agricultural use, does not meet the statutory requirements. That doesn't mean the property appraiser is not going to grant it.
Right.
Because the statute is open to interpretation.
Yeah, you're saying, look, I respect the fact that the property appraiser is a constitutional officer and they can make a decision.
They can make a decision.
And
if you look at the statute for agricultural classification, it is very subjective. There's a lot of factors that are taken into account. However, no one factor is determinative. So that's why the property appraiser could make a finding that it is entitled to the green belt.
I just want to make sure, though, I understood how carefully you worded that sentence. In other words, here's the sentence, page 9. If the property appraiser does classify the land as agricultural, as a matter of policy, this may affect the county's code compliance action, but not because of the Right to Farm Act. I want to make sure I understand. So if the property appraiser does grant an agricultural exemption, or determine that there's a bona fide agricultural purpose on the property, does the county have a position yet on what it would do in this case?
I don't make policy decisions.
Who does? The executive, I guess. I'm
definitely not the county administrator. Adjoining to land development. The caution with an agricultural classification is that anything on the lot has to be related specifically to the agricultural classification. It's not you can do whatever you want with the lot now. Specifically, whatever they grant, if they grant goats, then things that aren't related to goats, such as the pod that's there and some of the other things, may not be part of the ag classification. He has to turn in specifically what he's using there, and has to be tied to it. So I can't say for sure it'll wipe everything out. It depends on exactly what's granted, if it's granted.
They really want me to tear down that goat house.
Well, it's not an answer to my question. I get what you're saying, but I thought I recalled in a previous hearing that if there was an agricultural exemption, the county would drop its case.
It's going to depend on the case and what the ag class actually specifies. So if he's granted this, and this, but not this, I mean, it's not a all or nothing.
Okay, so let me ask you this. So does it matter from the county's perspective whether a residence is established if the property appraiser grants the agricultural exemption on something that satisfies the county? Is that going to be an issue anymore?
The residence established is the way to be able to have animals and have the farm. So that would be up to the property appraiser as to how they're going to assess that. I don't have a great all or nothing answer for you.
Here's what I want to know, because here's what I'm going to do. I'm going to issue findings on the applicable questions as to whether or not the Right to Farm Act applies as to all this. But and I am going to find that the property is in violation. But I want to be able to explain what Mr. Breeden has to do to bring the property into compliance. And if one of those things is getting an exemption from the property appraiser, I can't put that in the order unless I understand what satisfies the county for him to achieve.
Right. He doesn't have enough acreage to put a house there and still have animals. That he doesn't have that much acreage. I know he's got extra lots he's talking about. They're separated by platted roads. You cannot count that. I know there's a definition of a butt in the LDC. We can't do that. It's per lot. So establishing a residence there is not going to allow him to have the animals. It would allow him to have some of the storage items that he has there. as accessory.
What does the county need to see from the property appraiser in an exemption in order to consider this abated?
They would give us a copy of what the ag class actually determines and what the use was. And then there's a form they fill out with the building division that says, here's the uses, here's what was granted, I want exemption from permitting for this, 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 and this. And that goes through the building division, and then we have it all documented.
But what is the this? What does the county need to see?
That's what I'm trying to say. What I don't know what the property appraiser is going to approve, and I don't know what he submitted to them. I know he did submit a request.
Mr. Braden, did you submit a request?
Yes, sir, absolutely.
Right, I've confirmed that with the property appraiser. He has. So if he asks for goats and chickens and pods and tractors, all of those, if that's it, we're done. If he asks for that but didn't include a shed that's on there that is completely unrelated.
Okay, so what you're saying is you haven't seen the application. And number two, if the exemption doesn't cover everything that's on the property, then the county may still consider it to be in violation.
Correct. I mean, we're trying to get compliance, absolutely. So if the ag class covers it and he's using it for agriculture, we're good. We're done. But right now, the only abatement, because he doesn't have that yet, is to remove the items because he doesn't have the acreage.
Mr. Breeden, what do you, I want to find from the evidence, what do you have on the property?
It's a Connex box we use to store hay and feed.
What do you,
A Connex box.
Connex blocks?
Shipping container.
Okay, a shipping container.
There's a couple wire spools.
I'm from the main streets of Orlando. We don't know a lot of shipping container stuff. So there's a shipping container that has what?
Feed and hay and tools and some deer feeders in it.
What else do you have on the property?
There's an awning that we use to cover hay and a feeder and put the tractor under that most of the neighbors use more than I do. And then there's a goat house that we talk about, and the first I built with my kids in like an hour out of sawmill lumber, which the county really doesn't like.
But there are animals on the property, correct?
There is.
What animals are on the property?
There's just goats.
Goats.
And some raccoons, but they're not mine. They just show up.
You're not concerned with what happens to the raccoons?
They ate the chickens.
They ate 14 chickens, so they can have the place.
Wow. They earned their spot.
Yeah.
Does the county contest what Mr. Breeden's represented as being on the property?
No.
Okay. I'm going to issue some findings based on the briefs, and then I'm going to ask for Mr. Breeden's objections and position. I'm going to ask for the county's objections and positions. So we have to put our findings on the record for the purposes of eventually memorializing the order. First, I am going to find that the Florida Right to Farm Act does not prohibit the enforcement of the code as the county seeks to do here for the reasons that are in the county's brief. I thought that they were correct. In other words, the Right to Farm Act doesn't prevent the enforcement of codes enacted prior to the Right to Farm Act, which this code section is, although it's been amended, but not in a relevant way for this case. I will find that the Citrus County Property Appraiser's classification of respondents' land as agricultural may affect the code compliance action. In other words, if the property appraiser takes certain actions based on the application from the Breedens, then there won't be a violation, and that will be a way to abate the violation. I'm also going to find that the respondents' placement of goats and formerly chickens on the property is not permitted in the rural residential district absent some other permission from the county. In addressing Mr. Breeden's brief, I thought it was really useful to look at the tables for the different zoning. Again, I'm reiterating a finding from a prior hearing that I believe that this is residential zoning, not agricultural, although there's an agricultural use permitted. The reason why the table was helpful is because it showed what kind of agricultural uses are available. And I accept that in Mr. Breeden's brief that some of the representations in prior hearings may not be accurate about what's on the property based on what's been testified to at this hearing. So what I'm going, actually, Mr. Breeden, what is your position on my findings?
So I agree with your findings. I thought it was a great brief. My concern, well, first, so we're back where we started, and me and just for the record, me and JC had a 30-minute phone call in the beginning of this, and we landed where we are 4 months and many thousands of taxpayer dollars into this, right? And so my concern is that that's wrong, and what I laid out and how the Right to Farm Act, and the reason I brought it up to begin with, is exactly what I laid out in the brief. Other than a couple folks, everything I got from Citrus County coming in here was no, 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 no. Well, how can you help me? Well, no, that's not my job. Okay, well, we're not going to do that. And so I would say that my position still remains, that I did ask the county to provide where the code or the law talks to land separated by roads, specifically as it pertains to agricultural use. And that's mostly what I just want to know as I go forward here, right? And so I still can't get an answer, which tells me the county's not sure either, or else they support my argument in my brief that the county has been less than helpful in this, which is what the Right to Farm Act's secondary intent was, to get encouragement of agricultural activity in the state of Florida. So
It's an interesting thing. I mean, I think, Mr. Breeden, that the county can't act as your attorney, however, and so for the purpose of analyzing how platted roads function and how they separate property, it's a fairly difficult analysis. I'm speaking to you as a board-certified real estate lawyer. I encourage you to retain an attorney to help advise you on that. But I think your point, part of the reason why we're here is because you raised excellent defenses. I had no idea how the Right to Farm Act applied, and I required briefing in order to understand it. So that's not really the county's fault or your fault. It's my fault. I need to be educated on how your defense applies. I don't think it does, but I do think your exemption defense applies. And so what I'm going to do, what's the county's recommendation on this case?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
Mr. Breeden, have you been in touch with the property appraiser about them making a decision?
So it's back, so I kind of got strung along there too. So it was, it's got to be filed by 1 March, you'll have a decision. So the last I heard, I presented 2 hearings ago, I think June 30th, they said, is when they'll make their decision now.
Have they put that in writing or said it at a hearing?
No, so they've said, hey, we have this process. This is the process. We go through the process, and as she said, it's everything within the agricultural exemption is very broad. No one factor can deny it, and so I foresee a problem there. I'm looking forward to the fight there because being a former Army guy, you either meet the standard or you don't. And so I feel I have significantly exceeded the standard for the agricultural exemption. So I'm comfortable in taking.
Well, there's
that.
another Army guy. His name was Douglas MacArthur, and what he said is, in war, there's no substitute for victory. So that's what you got to get. What I'm going to do is, I'm going to find that the property is in violation. I'm going to grant 120 days to abate the violation, based on the fact that there does seem to be a way to abate it by working with the property appraiser, and I'm hoping that's a sufficient amount of time to do that. The ways to abate this are going to be either removing all offending things from the property, that is the shipping container, the awning, the goat houses, and the goats themselves, or getting an exemption from the property appraiser to permit those things on the property. If the property is not brought into compliance as ordered, a fine of $50 per day will accrue. If the violation is not brought if that fine will be recorded and will constitute a lien on the real or personal property, the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. and the Breedens will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Sir, I would have asked for consideration and asked for 180 days. The reason being is it'll take 45 days to contract a heavy haul out of Marion County to move that Connex. Citrus, Hernando, and Pasco County don't have there's no company here with the capability, so I have to get a 40-foot landau out of Ocala, which is how I got it down here from Hog Valley. So June 30th is their deadline. 120 days puts me at 30 July. I'm not going to be able to contract in that amount of time. So in other words, if I wait for their decision, I'm going to need 45 days. If they say no, I'm going to say, okay, I got to put on contract a heavy haul to come down here and move that box. Last time it took me 45 days to get one, just because they're so busy.
Okay, I hear your point. I'll amend from 120 to 150. I think that's legitimate. Is there any comment or objection from the county?
No objections.
All right, thank you, Mr. Breeden.
It's a different one. I sent another one to
The next case will be Commonwealth Trust Services, LLC, and 115 North Country Club Land Trust. Code Officer J.C. Charlton.
Or I'm sorry, Ms. Gross, did we not have the administrative order ready?
I just sent you another one, if you could go get it.
So you want
Oh, I'm
me?
sorry.
Yeah, there's two administrative procedures for code lien.
If we can handle that case, I think we should, because we still have Mr. Shoemaker
I
here.
can't, 'cause it's in my email.
We need to have our own printer in here, I guess.
Yes.
I'm going to recall case 215-3458, Mr. Hamill.
The provision you have is for releases by the administrator. Ms. Spiros is getting releases by the special master.
Okay.
Called releases, but it does also allow the reduction of liens.
Wow.
I mean, the fines.
Okay.
And it's based on good cause shown. You can adjust the fine. The only thing that you're prohibited from doing is reducing the administrative costs.
Interesting.
And this is set by policy of the county. It's not covered in the ordinance. It's not covered in the statutes.
Well, I believe it is covered in the statute.
Well, there's a review process. However, it doesn't spell out what you can and cannot do in the statutes.
Yes.
And in fact, the statute has been found to be unconstitutional to some extent because it doesn't allow relief to an owner.
Wow.
So we have our procedure which does allow for relief to the owner.
Then has a copy of this been provided to Mr. Shoemaker? Or?
Lori's getting the one that concerns the special master. This is for the administrator.
Let me take one moment and then review Administrative Regulation AR 10.11-4 from the County Administrator. Only take a second.
And if I may, too,
Yeah.
Your Honor, there's a line of demarcation in both the statute and I think in your policy, too, as well, once there's been a lien imposed. But prior to the imposition of a lien, which I think we're not at quite yet.
That's correct, and that's what, since the lien has not been imposed, there's a different AR, which Lori's getting right now.
That's just what I need to understand.
Yes.
Yeah.
But the actual statute, 162.03, says a special magistrate shall have the same status as an enforcement board under the chapter. That's it's verbatim from the statute.
All right.
And then 162.09 says an enforcement board may reduce a fine imposed pursuant to this section. Once it's a lien, then that goes over to the actual government authority. In this case, the Board of County Commissioners would be the only one that could reduce a lien.
Mr. Shoemaker, you're going a little quick. So you had mentioned 162.03 first?
162.03 subsection 2.
Okay.
And it's a paragraph long, really. I think the third sentence says a special magistrate shall have the same status as an enforcement board.
Right.
Under the chapter.
Right.
Some counties or some cities have a code enforcement
Correct.
board, some have a special
Right.
magistrate or
Right.
special master. And then the next statute, if you follow further down, 162.09,
Okay.
subsection C says an enforcement board may reduce a fine imposed pursuant to this section. Otherwise, again, and the special magistrate has that same authority, but once it becomes a lien, then they lose the ability to do that. In fact, there's also an Attorney General opinion, specifically on point. I understand Attorney General opinion is not binding, of course, but that there's no specific time frame on that. It says the statute doesn't impose a statutory time limitation, which is AGO 93.91, on the authority of a municipal code enforcement board to reduce fines imposed under that section. However, the board may establish a rule, a uniform procedure for reconsideration of fines imposed by the board, which includes a time period for considering the reduction of a fine. And in a sense, it sounds like that's what Citrus County's done
I agree.
by allowing us to appeal the fine itself. So it's certainly permissive. It says may, it's not a shall. And, you know, we're here today at the, if you will, the mercy of the special magistrate today regarding reduction of the fine.
All right, so for the record, I've been provided a copy of Administrative Regulation 10.12-2. I'm looking at the procedure number 4. Here's what it is. The special master shall consider requests for release of fines during a public meeting. The special master shall render a decision on the request. However, at no time shall the recommendation for release of fines be greater than the amount necessary to cover the administrative costs of inspection and prosecution. At no time shall administrative costs be waived. Number 5, a request for release shall not be accepted if, among other reasons, the request is incomplete, the violation has not been abated, relief is sought for a repeat violation, the property owner did not use his or her best reasonable efforts under the circumstances to abate the violation, the amount of administrative costs has not been paid in full. Is everyone ready for me to make a ruling? Okay. So pursuant to the policy, I'm going to make findings that the request is complete, the violation has been abated, relief is not being sought for a repeat violation. The property owner did use their best reasonable efforts under the circumstances to abate because it has been abated. Legal counsel is here. I've seen the photos. And therefore, I'm going to consider the request for release and release the fine insofar as it does not cover the administrative costs of inspection and prosecution. Those administrative costs, whatever they are, shall remain. And does anyone have any questions?
I believe it states that they shall be paid in 30 days.
Number 7 of the policy, after the special master renders a decision, the owner shall pay the outstanding reduced fine and/or administrative costs within 30 days, unless the county administrator approves an alternative payment schedule. So I will just incorporate that wording into the order, finding that it shall be paid, the remaining administrative costs shall be paid within 30 days unless the county administrator approves an alternate.
We'll get them paid today, Your Honor.
First of all, does anyone from the public wish to be heard on this case? I think there is. So I have to allow a member of the public to be heard before I end the hearing. Ma'am, could you please come up and be sworn in?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Can you please state your name?
My name is Sandra Niver. I'm a resident of this community where this violation has taken place. And I've lived there 22 years. I go up and down the same street day after day, year after year. And for the last better than 6 months, I have had my vision blocked to where I could not even make a left turn without pulling into a street before I could even make a right turn to get out of my subdivision. And it's a subdivision of 125 homes, so it's become an issue with our residents that we couldn't even get out without pulling into a main drag. And I'm glad, very thankful that this has been taken care of, very glad that code enforcement really pushed it because it was turning into a nightmare for our residents. And we're happy that we're happy it's over. Thank you very much.
Thank you, ma'am. Mr. Shoemaker, anything else?
No, Your Honor.
All right, then this hearing's over.
Thank you.
Good to see you, Mr. Shoemaker.
Next case, Commonwealth Trust Services, LLC, and 115 North Country Club Land Trust. Case number 216-0213, Code Officer J.C. Charlton, page 6 of your agenda.
Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name for the record?
Jemima Doozy?
Thank you.
Is that Doozy?
Yes.
Doozy, thank you.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 216-0213. Case for accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Code of Ordinances. The address is 1115 North Country Club Drive in Crystal River, Florida. Property owners, Commonwealth Trust Services, LLC, and 1115 North Country Club Land Trust, August 2nd, 2021. Good service via posting the property and at the Lecanto Government Building. Would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on March 9th, 2022. Corrective action inspection on March 23rd. Photos of my final inspection on April 19th, 2022. Exhibit B, a copy of the notice of violation and notice of hearings, photos of the posted property, and a copy of the posting affidavit I completed.
Ms. Ducey, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
No objection.
Okay. Is there anyone from the public who's going to want to be heard on this case? Okay. Let the record reflect that there's no response. Without objection, what's been proposed as exhibits A and B are evidence?
Your Honor, can I say something? I don't represent Commonwealth. That I only have about 75% of interest in that property. So I was outside of the country when they sent me the email about this hearing.
Let me ask you about that. So I want to make sure I understand what you're saying. So it says here that the owner is Commonwealth Trust Services Land, and there's a bunch of other stuff. It's a land trust.
Exactly.
And you own, you have a 75% interest in that land trust?
And that property, because it's a compiled multiple properties in that trust. So that specific property, I got 75% interest on it.
So normally in a land trust, there are, by the way, we're getting another call from Title USA LLC. It's a 352 number, okay. Mm-hmm. Normally in a land trust, beneficiaries own certain percentages, right? So you're saying that your ownership interest is a 75% interest
Correct.
In the trust. Okay.
Correct.
Well, it's still a pretty big portion, and it usually in a land trust, what that means is that you have the right to direct the trustee how to act. And so your point is that you weren't given notice of it until fairly recently?
I wasn't. They sent me the email because I was outside of the country.
You got an email?
Yes.
Okay.
So I had to flew back in because I didn't know if they were gonna be here.
Okay.
Because it's been a nightmare. I've been going back and forth with the contractor. So basically, I got on them. They started to do the cleaning. So I'm on my way over there now to see if they finish it, so I can go ahead and make sure they take the right actions.
These are good points, Ms. Ducey, and I want to hear, but first, I usually let the county present its case. I wanted to hear what you had to say about the notice, because that's actually important before we get to the case.
Correct.
But the county's not under an obligation to send an email under the notice provisions. What they're required to do is send mail service, and if that doesn't work, it's a post-it on the property. They've done that. So let me hear from Mr. Charlton, and then I'll get back to you.
Okay.
On March 9th of 2022, I conducted my initial inspection and observed building debris, scrap wood, and roofing materials on the property. I haven't had any contact with the property owner until today, or representatives until today. There has been good progress made on the property. They had a roll-off dumpster at some point out there. As of April 19th of 2022, the remaining debris on the property is on the left side of the home. and the property remains in violation with that debris there.
If they had a permit to be doing work on the property, I mean, is there a permit pulled for any of this? Do you know?
I notified building division, and we did check for a permit. There is a roofing permit for it, but the item still should be contained.
So even when a permit's been pulled for, I mean, this isn't all roofing, but so I get what your point is, but let's say a permit's pulled for everything.
Mm-hmm.
Even when a permit's pulled, this all has to be contained by the contractors doing the work?
Yes, sir.
Okay. Ms. Doozy, I would like to hear what's going on the property.
Well, that property was supposed to be finished since last year. So again, it's been a nightmare with the contractor, and I have find out after everything's said and done, they have an issue with the previous dumpster company that he has not paid. That's one of the reasons why they pull it out. So basically, I have them get into it right now to get it fixed. I'm on my way over there to make sure everything is it's okay. What I'm asking to do, please, if we can give like a little time to make sure, because I wasn't here. I take the matter into my own hand and reach out to people that I need to make sure they get into compliance. So.
And let me just check with the county. So is the only thing that's out of compliance that one stack of stuff that you took a photo of?
Yes, sir.
That's been massive improvement.
Yes.
How much time do you need to take care of this?
It's at least 30 days.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
And by the way, I didn't mean to lecture about what land trusts do. They're
No,
just
that's
fairly
okay.
sophisticated, and I wanted to get on the record what was going on. All right, so I do find that the property is in violation. However, I'm going to grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the land trust. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
Thank you.
Thank you.
Next case, you know what I wrote to them. I was gonna do Jagir, is that okay? Vaughn P. Jagir and Andrea C. Kelly, case number 215-7544, Code Officer J.C. Charlton. Joanna Katu is the expert, and this is page 9 of your agenda. Mr. Jagir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Welcome.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-7544, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 11567 North Kayak Point in Inglis, Florida. Property owners Vaughn P. Jagir and Andrea C. Kelly. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on January 20th, 2022. Corrective action inspection on February 24th and photos of my final inspection on April 19th, 2022. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the signed certified mail return receipt, and copy of the property appraiser's report listing the property as vacant.
Mr. Jagir, is it?
Yes,
Can I ask you to take a look at these documents and take your time and let me know if you have any objection to them being used as evidence in this hearing? there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response that I can see or hear.
I'm sorry?
I was just making a statement for the record, sir. Without objection, what's been proposed as Exhibits A and B are evidence.
Thank you.
Thank you.
I conducted my initial inspection on January 20th, 2022 and observed a shipping container on the vacant property zone Coastal Lakes Residential. I've had contact with the property owner and explained the violation, stated it was items in the container from one day when he might build a home on the property. Explained that there were no permits for a home on the property. He stated he would need some more time to abate the violation. Additional time was also given. As of my final inspection on April 19th of 2022, the connex container remains on the vacant property.
Is there anyone else from the county who wishes to testify?
Yes.
Yeah, Adjoining Coutu Land Development, it is CLR, it should be vacant. This is a waterfront lot in the flood zone, so the base flood elevation is about 10 feet up too. Another consideration, just having this on the ground is a concern with FEMA as well.
Why?
Our FEMA comes and evaluates us every year, so if they see this lot and see something on ground without flood vents or anything, that could hurt us.
In other words, that there's something that looks like it's impervious and
without flow-through vents, right, or
Okay.
raised, yes.
Okay. Mr. Jagger, I'd like to hear what you have to say.
Well, I have been trying to fix this with him, this gentleman, and I run into the same problem this one of the other gentlemen had with the container companies. I had finally got them out there a couple weeks ago, and I was asking them to remove the container, and I had it set up for them to get it out of there, but when they came out, they told me, you can't move that container with it being full. They wouldn't move it. So then I had to get into hiring a company to come out and unload it, and that was completed this week. They have since today told me that they would be back now to get the container, in fact today. I'm not in control of that, but that's what they promised me.
Let me make sure I understand. So are you saying that the response time from these people picking up the containers is faster than what you heard earlier from Mr. Breeden?
No, they're extremely slow.
Okay, so how long is it taking?
It's probably taken me a month.
Okay. Well, it's a little faster than
and then it took me an extra week to get it unloaded.
I got you.
Because it was complete house.
How much time do you need to fix
I don't need
this?
any more time.
Well, you don't think you do,
Well,
but
okay.
but
well, yeah.
you're also, at the mercy of the shippers. So,
I am.
Okay. Mr. Charlton, have you heard anything that you disagree with?
No.
All right. What's the county's recommendation?
Citrus County Code Compliance Division, in respect for request of special master, assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions to the violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
I'm going to adopt the county's proposed findings of fact. I will find the property to be in violation, but I'll grant 45 days from today to abate the violation. The reason being that if they come out here again and then you have to wait another 30 days to get it for some unforeseen reason, looks like there's been cooperation. So these are factors taken into account. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. The fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months after the date of first recording, and the property owners will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
And if they do get it today or this week,
Let the county know, and then you're done.
I'll go out. Okay.
Yeah.
Appreciate you.
All right.
Next case, Louis Sansone and Yvonne Sansone, case number 213-6359. Code Officer Matthew Hampton. Joanna Katu is the expert, page 18 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Can you please state your name for the record?
Louis Sansom.
Thank you.
Good morning.
Morning. Matt Hampton, Citrus County Code Compliance Officer. This is case number 213-6359, 3102A, special requirements for all accessory structures, a violation of the Citrus County Land Development Code. Address is 8144 West Pebble Lane, Homosassa, Florida. Property owner is Louis and Yvonne Sansom. I have good service via signed certified mail return receipt. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A will be photos I took during my initial inspection on March 25th, 2021. A copy of the notice of violation sent on the same day, March 25th, 2021. Exhibit B will be a picture I took on February 1st, 2022, starting the case as if it were new, due to the time in between the last inspection. Photos I took for my corrective action inspection March 22nd, 2022, and the photos I took during my final inspection April 19th, 2022. Exhibit C will be a copy of the property appraiser's report showing the property is a vacant parcel, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Mr. Sansom, I'd like to ask you to take a look at these documents, what's been proposed as Exhibits A, B, and C. Take your time in doing it, and let me know if you have any objection.
No, sir, he takes better pictures than I do.
Me too. All right, so sir, without objection, what's been proposed as Exhibits A, B, and C will be evidence. Is there anyone from the public who's going to want to be heard on this case? I don't see or hear anything, so let the record reflect that. Thank you.
Yes, sir. Good, sir.
Yeah, please.
I conducted my initial inspection on March 25th, 2021, and I observed the property to be in violation of storage for the violation listed above. There was a shed, boat, and trailers on a vacant lot. I issued the first notice of violation on the same day. I had contact with property owner Mr. Sansom, and he explained that he lives down the street and uses the property to park his trailer and his lawnmower in the shed. He also felt that it was unfair that he was unable to utilize his property in the way that he wants, and he said, especially considering he said he keeps it up so well, and said he would like his day in court or to plead his case. I had some health issues and lost track of the case, and I conducted a follow-up inspection, basically starting the case over again to make sure due process was correct. And on February 1st, 2022, I again found the property to still be in violation. The shed was still there with the trailer. I issued the second notice of violation. I again have had contact with Mr. Sansom, and he expressed his desire to be heard. My corrective action inspection was completed March 22nd, 2022. Property remained in violation. The notice of hearing was issued, scheduling the case for today's hearing. I conducted my final inspection April 19th, 2022, and observed no change.
Property does look nice, Mr. Sansom. What would you like to present?
I believe when the gentleman came out, I tried to show him some pictures I had of my camera. I also have some pictures here from 2019 showing the property when I bought it. It had a pre-existing building on it, which was in a state of disrepair. I removed the building. I put a small 64 square foot building back on it, as you can see in the photos. I still maintain my lawnmower there. At the time that he came out and gave me the fine or initialized the violation, I removed the boat and the trailer that was there. Now it sits in the front yard of my neighbor, which it was his boat and trailer. The trailer that you see sitting on the lot belongs to me. I have photos here that if you care to see of the shed, what's in the shed, which is the lawnmower. We live a third of a mile from there. None of my neighbors around there have any issues with me. They think the place looks nice, and I intend to keep it that way. The one person that initialized this was Catherine Schneider. All the code violations, gentlemen know her, I believe, because she is the only one that brings about this mess in our neighborhood. I don't understand why she has a problem with me, because even in their words, the violations that they passed to get to our place was incredible. I don't understand it. The place looks much better now. I intend to take care of it. I do understand the fact that nobody wants to have a lot next to them with garbage on it, vacant trailers and so forth. I don't intend for it to go that way. We take care of our stuff. The boat trailer's tagged. Where I live at, my boat is in the water, and that's the reason that trailer is there. We have a very small yard where I'm at. I keep insurance on this property, the vacant property. So, man, I'm trying to do everything, and right, I just don't understand it.
The reason why I've taken the testimony in this order, Mr. Sansom, is because I wanted to hear what you had to say before we hear from the county's expert. I think the county's expert is going to be able to explain why the situation is. I mean, I'll take a first stab at it. You've chosen to live in Citrus County, which has a land development code, and it does have regulations on what you can do with the property and certain things. But I would like to hear from the county's expert.
Adjoining to land development. This is a CLR MH designation, Coastal Lakes Residential Mobile Home Allowed. There's no principal structure on the site. You can't have accessory structures first. You have to establish a principal structure, and we don't have anything there.
In other words, what you're saying is because this is a residential zoning, it has to have a principal use of a residential structure before accessory structures and accessory uses can occur on it, correct?
You're correct. If there was a house here, the neat stuff around it would be fine, but unfortunately there's not a house here, and you can't put storage on a lot vacant. You need to have that residence established first.
Are there examples of zoning that allows storage on it without a principal structure?
No, the storage would have to be a primary use in like commercial.
Okay. Mr. Sansom, does this make sense to you?
No,
Okay.
it doesn't. Photos show it's obvious that there was a well there. You can see the well. I have it highlighted on some photos. I believe I showed the gentleman there. It's got concrete slabs there, and it has a power pole there. It wasn't vacant land at one time.
Right.
And it had a pre-existing building there. I may have overstepped my bounds by rebuilding the building, but
no, I mean, so what this means is that this piece of property is zoned in such a way that if you had a principal structure there and the principal structure was removed, then the accessory stuff has to go. And this happens sometimes. Sometimes houses burn down. Sometimes, so either there's a rebuilding of the principal structure or the accessory stuff ends up having to go. It's code section 3102 in the code. And I strongly encourage you to review it, but what it basically says is all accessory uses, regardless of location, shall be allowed once a permit is issued and meets the following requirements. Accessory uses or structures may not be placed on residentially zoned property prior to the establishment of the principal use. And so both the shed and the trailer, the shed is an accessory structure, the trailer it's basically an accessory use because it's storage, cannot be placed on residentially zoned property, this property, prior to the establishment of a principal use. And you've been here, you're not the only one here with this code section issue.
that.
So it's being applied equally, and
No, sir, it is not.
and well,
If it's
Understand-
applied equally, why isn't?
I'll tell you, I already know what you're gonna say. The reason is that the county, every code enforcement in the state of Florida functions based on complaints. And this is part of a new law, by the way, signed,
I understand that.
you know, and so it's, code enforcement can't just stroll along and see things. There has to be a complaint. And so, based
So
on.
you're telling me that, for lack of better terms, little Hitler can walk around and pick and point to who she wants to have you guys mess with?
If a resident, if someone
She
calls
is the
and
resident.
complains, I won't characterize if they're compared to Adolf Hitler or not. I don't know that. I suspect that probably not as bad as Hitler. But regardless, I think your point is correct, that is how the investigations work. And all I mean is I have to apply the law equally. So do you understand what has to be done to bring the property into compliance?
To be in compliance, do I have another option? I mean,
Yeah.
zoning, or can I change the zoning on it? And I'll be honest with you, I thought somebody told me that, hey, you know, to look at changing the zoning, so I thought about that. But the truth of the matter is, if you change the zoning for me, I don't want the guy right down the street doing the same thing, because I don't want to live next to his garbage.
That's the flip side of zoning. You know, in some respects, it's really burdensome about what you can do with your property. On the other, people like it because it keeps the character of an area. So you're right. But the question is, can it be rezoned? Any property can be rezoned, I suspect, but I don't know if that's something that the county would consider, and I can't make a representation about it. That is part of why I preempted. I thought you might bring that up, so I asked, are there zonings where that might be permitted? And so there are ways to abate it. None of them seem particularly pleasant to you, but that's the law.
This is the law.
So do you have evidence that you want me to look at and to introduce into the record in case you want to appeal this?
I can show you just.
We have to make a record. Now, are these things that you're prepared to give up and
Yes, sir.
have? Okay,
Yes, sir, they
so
are.
what I'd ask you to do is to show whatever you want to the county first, and then we'll see if they're permitted as evidence.
These were just from the Google from 2019 of the pre-existing building. Let me make sure I got this right here. And here's another view of it, along with the power pole. See it here?
Yes, sir.
And the lot before
you took over.
1/3 of a mile to their property that in violation in our home.
Yes, I've been there. You took me.
I thought so. And just, the only thing I could give you is the way it looks now. That's the best I can do.
I'd like to know if the county has any objection to these documents being respondents' exhibits.
When you bought it? No, we have no objection.
Okay, then I'm going to introduce these as a composite exhibit, Respondents A, and I'll just take a moment to look through them. Okay, and so Mr. Sansom, I see a photo with some arrows on it. I think what you're doing is you're directing me to some of the things you talked about earlier.
Yes, with the well bin on the property, power pole, so forth. We probably should have did our homework before we bought the property. We I guess some things have changed, and if you leave stuff uninhabited for, what, a year now, it's considered vacant.
Okay, I see. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for inspection.
Can anyone tell me if there are any zonings in that area nearby that aren't residential?
He's out in the middle of a residential area. You'd have to go to the major roads and possibly see Coastal Lakes commercial. This would really be a spot zoning. I don't think it's very likely.
I understand. The reason why I ask is because in creating the order, providing the amount of time, I wondered if that amount of time should factor in a rezoning application. But if this is spot zoning,
I think it's very unlikely, unfortunately.
Yeah. Do you know what spot zoning is?
No, sir.
Spot zoning is where someone requests a change in zoning that is totally out of character, connected to everything else around it. And so it's, even though it's technically allowed, the county can do whatever it wants, frankly, it's usually not considered a best planning practice, and it's usually considered highly unlikely that it'll be granted. Meaning that when I issue the order finding the property to be in violation, it wouldn't really make sense for me to allow 6 or 8 months for you to rezone the property. Does that make sense?
Yes, sir, it does.
I am going to find that the property is in violation, but I want to know how much time you think you might need to bring the property into compliance.
Could I have 2 months, 60 days?
The property owner is granted 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Sansoms. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Good luck.
Thank you.
Next case, Stanley J Kozicki and Mary Ann Kozicki, case number 215-8385, Code Officer J.C. Charlton. Joanna Coutu is the expert, page 12 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please state your names for the record.
Stanley J Kozicki.
And Mary Ann Kozicki.
Thank you.
Welcome.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-8385, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 100 North McGowan Avenue, Crystal River, Florida. Property owner Stanley J. and Mary Ann Kozicki. Good service via signed certified bill return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 3rd, 2022, and photos I took during my final inspection on April 19th, 2022. Exhibit B, notice of violation, notice of hearing, copy of the signed certified mail return receipt.
Sir and ma'am, I'd like to ask you to take a look at what's been proposed as Exhibits A and B, and let me know if you have any objection to them being evidence in this hearing.
No objection.
Okay. Without objection, then, what's been proposed as County Exhibits A and B are evidence. Is there anyone from the public who's going to want to be heard on this case? I do not see or hear any response.
We didn't leave any trees there.
Okay, thank you.
conducted my initial inspection on February 3rd of 2022, I observed vacant property that was completely cleared. While researching the property, I found that there was no permit on the property. I've had constant contact with the property owners with updates, and a permit was applied for on March 30th, 2022. As of my final inspection, no permit has been issued and no change in the condition of the property.
If a permit is issued, well, actually, does the county have any other witnesses who wish to testify?
Adjoining to Land Development. He's correct. They applied on March 30th. It has not been approved yet. I did ask for it to be expedited. I expect it'll probably be approved sometime this week.
Are you aware of any deficiencies or problems?
At this time, no. It's been approved by several divisions already.
I see. It's working its way through the process.
It's working its way through, and I do expect it to be done shortly.
If a permit's issued, does that abate the issue? Or
other than the fact the trees are gone, yes.
Would all those trees have been allowed to be removed if a permit had been issued?
That's what
I don't know because I haven't seen the how many that's part of site review and they haven't completed their review yet. So they will have to either replant or do that. That's part of site review. They'll make them do that. So with the house,
is the county seeking any penalties for an irrevocable damage that's occurred?
Just a daily fine.
I'm sorry?
Just a daily.
Okay. Mr. and Mrs. Kozicki, I'm sorry, are you a Mr. and Mrs.? I shouldn't have assumed that. You could be siblings. I don't know.
I'm the Mr.
Okay. Okay. Well, yeah, that's right, too. We never know these days. Don't make assumptions. What would you like to say, if anything?
Well, we did everything in good faith. We went down to purchase a new modular, and they said, okay, to get things started, get the land cleared so that we can have it surveyed and go through all of the steps, which we did. And as soon as JC reached out to us, we reached back to him. We contacted the entity that cleared the land, the modular company, kept going back and forth, and we thought, because we were given that permit number, so we thought, okay, maybe it's finally taken care of. So we reached out again. We just got down here about 3 weeks ago, drove by the land, and there were flags up showing where the house is going to go. So I thought, okay, good. That was Sunday. And Monday we get a call that no, it's still not taken care of. But we talked to the developers yesterday, and they basically agree with what she said. There's 8 permits, and we cleared 5 of the 8.
Okay.
So so our property's going up there.
In other words, it's gotten 5 out of those 8 in the last 3 weeks of processing. Okay, that's a pretty good rate. What's the county's recommendation?
Due to the nature of the violation, the Citrus County Code Compliance Division respectfully requests the special master assess a fine of $200 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is respondents' responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
Do you have any idea about how much longer? Has anyone told you how much time it should take before the permit's issued?
I mean, that's up to the county.
It is.
Yeah.
But I don't know if anyone's told you.
No.
Okay.
I have a question for Ms. Katu. I'm looking at the permit reviews, and on March 30th, it says the residential site plan review that denied because no site plan had been submitted?
Yeah, that, and then right after it, they corrected it. That was engineering, and it was a mistake. They fixed that.
Okay, so we don't have to wait for
Right,
the
we
site
don't
plan.
have to. I
All
do
right.
expect it'll be within the week. I just don't know how quickly they can get a modular established, but yes. I do expect that this will be done within a week.
In other words, what's needed to abate the violation, which is a permit, you expect that within a week?
I expect it to be ready to issue, yes.
Okay. Ready to issue, meaning that money would still have to be paid before they get it. And that is a tricky thing sometimes. Okay. All right, I'm going to find the property is in violation. I'm going to grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Kozickis. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the Kozickis shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record. Hopefully that's enough time. Does that make sense?
So in common speak, if it gets through in the next week, then we're good?
In common speak, once you get that permit, whether it's in a week or 2 weeks, and you've paid for it, then that abates the violation. And if they're not aware, you need to call and make them aware, and then it goes away. So there's a 60-day window for that to happen.
Okay.
Okay?
And then we can invite JC over for dinner?
That's your choice. But make sure he brings something. Okay? All right.
Yeah, absolutely.
Yeah.
Thank you.
All right,
See.
thank you.
Thank you.
Next, we have 2 cases. William Frederick Loy IV, Code Officer Amy Becker, case number 215-8428, and case number 215-8436. Joanna Katu is the expert on both. Pages 15 and 16 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record, sir.
William F. Lloyd.
Thank you.
Thank you, sir.
Do you want them together then?
Yes.
Okay.
And Mr. Loy, what she's asking, just in case it's not clear, is there's 2 cases here. I'm just asking them to do it all at once.
Okay. Thank you. Good morning.
Good morning.
Okay, case number 215-8428, accessory uses or structures, a violation of the Citrus County Land Development Code, section 3102A, and case number 215-8436, a violation of the Citrus County Land Development Code, section 4002, site development without a permit. The address for both cases is 117 South Thayer Avenue, Lecanto. The property owner is William Frederick Loy IV. I have good service via posting of the property as well as the Lecanto government complex for both cases. And I do have different exhibits, so I'll separate them out.
Okay.
On case 215-8428, I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken on February 8th, 2022, photos taken on March 1st, showing the posting of the notice of violation, photos taken on April 1st at my corrective action inspection, photos taken on April 7th, showing the posting of the property for the notice of hearing, and photos taken on my final inspection on April 19th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit. For case number 215-8436, I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 4th, photos taken on March 1st showing the posting of the property with the notice of violation, photos taken on April 1st at my corrective action inspection, photos taken on April 7th showing the posting of the property with the notice of hearing, and photos taken on my final inspection on April 19th. Exhibit B, a copy of the notice of violation, the notice of hearing, and a copy of the posting affidavit. Exhibit C, the copy of Google Maps showing road frontage and copies of the property appraiser aerial views.
Okay, Mr. Lloyd, there's a lot here. So you've been here long enough to know the way this works. I'm going to ask you to take a look at both sets of potential exhibits and let me know if you have an objection to them being evidence in this hearing. Don't feel rushed.
Can I ask you a question? What is this?
That's just a stump of a tree.
Okay, I'm just going to say that's an old stump because I didn't cut any big ones. I just want to let you know.
Okay.
I have no objections at this time on any of this. Everything she said is correct.
Okay. Then what's been proposed as Exhibits A and B in case number 215-8428 are evidence. What's been proposed as Exhibits A, B, and C in case number 215-8436 are evidence. Is there anyone from the public who's going to want to be heard on this case? I'll let the record reflect that I neither hear nor see any response. Thanks. Thank you.
I conducted my initial inspection on February 4th. I observed a vacant property and a large cleared opening in front of the property, which continued into the property in a pile of tree debris. While researching the property, I found there was no permits issued. On February 8th, when I conducted another inspection, I observed a white RV camper on the vacant property. I have had contact with the owner. He's aware of the violations.
And is that your presentation for both cases?
That is my presentation. I'm open for questions.
Well, so I understand, I think you testified to storage on a vacant parcel, which would be case number 215-8428, but you also have, I guess it's a tree removal case?
Correct. When I was out there on February 4th, I could see that it's almost like a road into the property. You can see through the pictures. Okay. There was a land clearing sign that I believe is one of the first pictures. When I called them, they had been contracted to clear that part of the property.
Okay, I understand. Is there anyone else from the county who wishes to testify?
Yeah, Adjoining to Land Development. There is a house permit applied for as an owner builder on April 1st. It was denied on April 8th by the building division. They're missing an HVAC duct layout. There's been no activity since April 8th.
Okay.
So once they clear the building division item, they may be able to get this issued.
Mr. Loy, so what's going on?
Okay, that's news to me because I have mini splits and there's no duct layout. So I don't know. I never heard anything from the. I've been waiting for the permits.
I see.
so
in other words,
okay,
in other words, what you've applied for shouldn't require a big HVAC. It's just got mini splits.
That's it. That's correct.
Okay.
Yes, and they told me that was fine when everything was A+. I had every document that I needed. So I haven't heard anything since then. If that's the case, I don't know what else to do from further. I guess I'll go over the permits. But I do want to say thank you. I bought 2 plots this year in this county. I'm moving my family over from Jacksonville. My mom's 82-year-old, handicapped. I'm sorry that I jumped the gun. I sold my piece of property. It sold within 3 days. I had all this stuff, and I'm trying to deposit things here and there. I'm always on time with A, B, C. I started looking for properties back last year. I started my plans with my drafter back in December. He told me 6 weeks. Everybody's slow. All right, so I jumped the gun ahead of time. I do apologize. I am trying to rectify everything, and I would like some time just to see if I can get these permits finished.
Well, it sounds important. I mean, I don't know if they're requiring an HVAC or maybe mini splits aren't good enough. I don't know. Does the county know why there's an HVAC rejection? Okay.
No, you need to go talk to the building division.
Okay.
The building division usually emails or advises when there's a denial in the process, but I'll direct him to building so he can find the answer to that question.
Well, Mr. Loy, assuming that the permitting process gets back on track,
okay,
how much time do you think you might need?
Soon as that's done, I'm ready to go. I had the whole.
Well, what are you building? Like, what's going on the property?
I'm building an A-frame, almost 3,000 square foot home on this house, on this property. I have 5 acres. All right, so I'm building an A-frame with 2 gables on the side. It's a big home.
Do you know if only mini
four-bedroom,
splits are allowed for that? I just don't
everything
know.
was
Okay.
Yeah.
But how long do you expect that to take to?
I handed
Well,
them
actually,
in.
a permit will remedy this, won't it? Okay, so he doesn't have to have the thing built. Well, actually, are you living on the property?
At this time, I'm living in the 5th wheeler because I figured I'd have everything ahead of time because I'm going to be building it on my own. But everything slowed down on me.
For this violation, the only thing that's needed is to obtain a permit, correct?
Can I get a temporary permit?
You don't have temporary permits. The RV living in can't be happening, so he can ask for that once he gets his permit issued if he wants to. But right now he has.
I see. So in other words, once the permit's issued, they'll be able to
ask for permission to live in the RV, but not until then.
Okay. That's not before me, however. He hasn't been violated for that, I don't believe.
That's the storage.
I have the RV only as an accessory structure on a vacant piece of property.
In other words, okay, I get it. So that is a part of the, it's not per se the fact that you're living there, but the fact that the RV is on the property is also a violation.
Okay.
You may be able to remedy it at the time that you obtain a permit. How much time do you think you need to get the permit?
I'm just waiting for the permits.
Okay.
That's all I'm waiting for, sir. I have money to build. I'm waiting. I have a hauler, actually, the end of this month. I had to put him out for the plot. And everybody's, and now I gotta wait. Now I just pushed him back 3 months because the permits.
What's the county's recommendation?
On case 2158428, the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given their severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection. On case number 2158436, due to the nature of the violation, the Code Compliance Division respectfully requests that the Special Master assess a fine of $100 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Mr. Lloyd, what I'm going to do is I'm going to find that the property is in violation in both cases. However, I'm going to grant 60 days from today to abate the violation, which based on the testimony I've heard sounds like it's more than enough time to abate the violation. However, just for the record, I'm finding the property in violation in both cases, and the time to fix both is 60 days, each individual. Let me get through it, and then I'll take questions. If the violation is not brought into compliance as ordered in case number 215-8428, which is the accessory use and structure case, then a fine of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of you, Mr. Loy. And in the case of 215-8436, if the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. In both cases, the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And Mr. Loy, you'd be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. I welcome your questions.
Question. The trees I can't put back. So what do I do with that?
And
most of these trees, there was none over 4.5 inches.
I don't know, Mr.
So
Lloyd.
for
The county
county-
may have as a condition of your permit that you replant some trees.
I have 5 acres of trees. There's still more coming down.
Well, that may be a condition. I can't speak to that.
Right.
but the permit being issued is what you need in order to abate the violation.
Okay.
So it's not really before me, but
So
I
as soon as
encourage
I have the permit and everything,
work with the county on whatever their tree requirements
Okay.
are.
like I said, I am trying to be in compliance.
Yeah,
I do
yeah.
want to be a good citizen and trying. That's all I can say.
Is there anything else from the county?
No.
All right, thank you, Mr. Laurie.
Thank you. Thank you for your time.
Next case, Thomas L. Turner, case number 215-9167, Code Officer J.C. Charlton, Joanna Coutu, the expert, page 23 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-9167, a violation of Land Development Code 3150B, fences, hedges, and walls. The address is 6263 West Soul Lane, Dunellen, Florida. Property owner, Thomas L. Turner. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it to be admitted into evidence. Exhibit A, photos I took during my initial inspection on February 17th, 2022. Photos I took during a corrective action inspection on March 21st, and photos of my final inspection on April 19th of 2022. Exhibit B, the notice of violations, notice of hearing, and photos of the posted property and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this case? All right, then there won't be any objection to what's been proposed as Exhibits A and B, and they are evidence in this case. Also, for the record, normally this will be posted on YouTube within the hour after the hearing.
You don't actually watch it, do you?
I sent one to my mom once.
They told me the views are very low.
I expected to hear a scream from the storage room, but there wasn't one. That's a professional right there.
An inspection was conducted on February 17th of 2022. I observed a fence constructed of pallets, and it was as tall as the 6-foot chain link fence gate in front of it. I have had no contact with the property owner. I have had contact with tenants at the property. Stated they will work on removing some of the fence to make it meet the height requirements. As of my final inspection on April 19th, 2022, there has been no change in the conditions on the property.
Is there anyone else who'd like to testify?
Oh, I'm sorry.
Joanna Coutu, land development. This is rural residential mobile homes allowed as a residential district, so fences cannot exceed 6 feet in height.
Cannot exceed 6 feet in height.
Correct.
I mean, is that the only issue with the fence here?
At this time, that's all. Yes.
Okay. It's just height.
Yes.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $100 per day alone for administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We'd also ask the Special Master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The property owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Turner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Next case, Marvin H. Partain, case number 215-7634.
Can I just ask why the other two Turner cases aren't being brought up?
Because Joanna's the expert, I'm trying to get her out of it.
Oh, okay, gotcha.
I very much appreciate that.
Yeah, that makes sense.
Working me hard.
That I get it.
I'm tired.
Marvin H. Partain, case number 215-7634, Code Officer Alan Jonason, expert Joanna Coutu, page 17 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 215-7634, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address of the violation, 3451 East Buffalo Lane, Hernando, Florida. Property owner Partain, Marvin H. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photo taken during my initial inspection on 21 January 2022. Photo taken during my compliance inspection on 21 February 2022. And photos of my final inspection conducted on 19 April 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the notice of hearing posted on the property, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no response. What's been proposed as exhibits A and B are evidence.
On 21 January 2022, I conducted an initial inspection and observed the property to be in violation. On 21 January 2022, a notice of violation was issued for special requirements for accessory structures, which is a violation of the ordinance listed above. On 21 February 2022, a compliance inspection was conducted with no change to the property. As of my final inspection on 19 April 2022, the property remains in violation and I have not had contact with the property owner.
Is there anyone else who wishes to testify?
Adjoining Coutu Land Development. This is low-density residential with mobile homes allowed. A brief history in April of 2021. Code by order removed all structures of the demolition on the site. It should be vacant.
Oh, I want to make sure I understand this. So in the photo, can you explain the demolition order?
The demolition order was April 2021, and that was to remove the primary structure. So the lot should be vacant at this time.
I mean, is there a primary structure on there?
No, not a permitted one.
I gotcha. Okay, I understand. All right. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Partain. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Partain shall be responsible to pay all costs required by county ordinance or reg, which may also be filed as a lien of record.
Thank you.
Thank you.
Thank you.
And I do have to take just a 5-minute recess. The time is 11:34. We'll be back at 11:39. The time is 11:39. I said we'd be back on the record at 11:39, and here we are. And Mr. Pearson is holding forth, and I'm sure it's... What were we discussing?
Whether or not Die Hard was a Christmas.
I thought you'd be going back there, but we settled that a long time ago. It ain't, and it doesn't matter what anyone says. It ain't.
Christmas theme.
As we say... anyways.
Would we like our next case?
Where were we? Yeah.
Jeffrey Young and Shannon Young, case number 215-8047, Code Officer Matthew Hampton, page 25 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name for the record?
Jeffrey Young.
Thank you, sir.
Welcome.
Morning again. Matt Hampton, Citrus County Code Compliance Officer. This is case number 215-8047. Accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of Citrus County Code of Ordinances. The address is 3195 South Kalai Terrace, Homosassa, Florida. Property owner Jeffrey and Shannon Young. Have good service via signed certified mail return receipt. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection, January 31st, 2022. Photos I took during my corrective action inspection on March 7th, 2022. And photos I took during my final inspection, April 19th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
All right, sir, I'd like to ask you just to take a look at these and let me know if you have any objection to anything in them, and take your time.
One thing is, I didn't get any of the information. I didn't get any notice because for some reason the county's only got the person I'm buying the house from. I got a she let me know last week that this was.
Who's she? Who is she?
Karen Cormer.
Karen Cormer, okay. We'll get into that. Then take a look through these and let me know if you have any objection to these documents. Okay. Is there anyone from the public who's going to want to be heard on this case? All right. Let the record reflect there's no response. What's been proposed as exhibits A and B are evidence. Mr. Young, I'll definitely want to hear more about that when it becomes your turn. Thank you.
I conducted my initial inspection on January 31st, 2022. I observed the property to be in violation of the ordinance listed above. There were pallets, furniture, broken items, and other debris. It appeared as if there was recently a fire in the front of the home. The notice of violation was issued February 1st, 2022. I conducted my corrective action inspection March 7th, 2022. There was a small amount of cleanup since the initial inspection. Notice of hearing was issued March 7th, 2022. I've had no contact with anyone regarding this property. I received the signed certified mail return receipt back that was signed for on March 11th, 2022. The name was illegible. As of my final inspection, April 19th, 2022, the pallets have been removed and there has been a small amount of more cleanup. There was still a door leaning against the steps on one side of the house, and then totes, trash, and other debris around the right side and the back side of the home.
Does the county consider like a lawnmower part of that, or what might be a generator? I can't really tell, but I mean, is that part of the debris under the county's case?
It can be considered part of debris, because if it's just kind of just put out in the middle of the yard, and I try to explain a lot of times that organization is key. When you have something, even if it is usable material, if it's just kind of put out in the yard, it almost looks like it's being just kind of discarded out there, even if it does run or does work. But my main concern was obviously the debris that appeared to be left over from the fire. and then things have been moved around side. It even looks like there's an appliance out back, a small case freezer, or what do you call them?
Mr. Young, are you the owner of this property?
I'm buying the property at the moment.
I mean, it lists you as the owner here, so my question is, are you the owner right now?
Yes, I think as a title, from the title company, it is that I am the owner.
Okay.
And like I said, the county sent the letter to the previous owner.
Actually, it went to Massachusetts. Is that Massachusetts or Maine, MA?
It's Massachusetts, and let me ask you this. I mean, have you lived in Massachusetts?
No.
Have you ever been to 133A High Street, North Billerica?
No, sir, that's the...
I'd like to know if North Billerica exists. I would.
May I explain the reasoning behind that?
Yeah, no, please.
Per state statute 162, which code compliance is governed by, we are required to send out any kind of mailing or posting that is a part of the property appraisers or the tax collector's records.
Oh, I agree.
And as of right now, the property appraisers indicates the address there that the notice of violation was issued to. So for him to get the mail to start,
I know why you sent it there. No, I get that. I assume that where you got the address from.
Okay.
It's just interesting to me. I don't really understand what Mr. Young is saying, because it sounds like on the property appraiser it shows him as the owner, and it also shows this address in Massachusetts. So,
I'm looking at the warranty deed.
Yeah, what is
and it's Karen Cormier. She has that address.
Right.
But this is a warranty deed to the Youngs, Jeffrey and Shannon Young.
When's it dated?
March 30th of 2020.
2020?
Mm-hmm.
Does it show the mailing address on the deed?
Her address is listed as the 133A
Yeah.
High Street.
Doesn't show one for the Youngs?
Yeah, the Calais Terrace.
Interesting. And the Youngs are the grantees on the deed? Okay. Well, it looks like the property appraiser just had a glitch and they kept the old address for some reason, but it's really not at issue because, unless I'm mistaken, let's see. Well, because you got a signed certified receipt, you didn't post it on the property, right?
That's correct, sir.
Okay, all right. Then how did you know about the hearing?
She let me know about a week
She
ago.
called.
Yeah.
I got you. All right. All right, well, tell me what's going on with the property.
Like he said, I did have a fire. It's been about 6 months. I've been working on it, trying to fix it up, and it's just a matter of money and stuff like that. And right now my driver's license I don't have one right now, so it's just a matter of being able to get stuff to the dump.
I mean, it looks like there's been improvement. Have you been making improvement since the notice of violation?
Since last week, yes, because that's the only time that's when I heard about it.
How much time do you think you need to fix it?
Couple months maybe.
Okay. I mean, when you say couple, that could mean different things.
Like 2 months.
2. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the action of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I think based on what you're saying about the notice, Mr. Young, I'll go ahead and grant, I'm going to find the property in violation, but I'll grant 90 days for you to fix it, bless you, based on the circumstances I've heard. And I'm sorry, Mr. Hampton, what was the recommended fine?
$50.
Okay. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed if it hasn't been fixed in those 3 months.
Okay.
Okay? This fine will be recorded and will constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record. Now, Mr. Young, do you understand what has to be done in order to fix this?
I gotta clean up all the garbage that's around there.
All the debris, and what Mr. Hampton testified is there's stuff that kind of becomes debris, even if it's usable, if it's just strewn across a lawn. Does that make sense?
Yes.
Okay. Do you have any other questions?
I do. Do I have to have a permit to put a fence on that property? No.
It's beyond I'm not going to answer
Well, no,
that.
I'm just wondering.
I would contact the county outside of the hearing.
Okay.
And since you're here, it's probably a great time to do it, but not during this special master hearing.
Well, I was just wondering since we're here.
Yeah. Well, I mean, look, is the county willing to answer that right now?
Fence does not require a permit.
Okay.
Okay. Well, there you have it.
But what I would do is it doesn't require a permit, but what I would do before you leave, go see land development up there, and they'll tell you the stipulations that go along with it, because there still are a few stipulations that you have to follow.
Okay. I appreciate that.
Thank you, sir.
All right. Thank you.
Next case, Dolores M. Schultz, case number 215-8326, Code Officer Matt Hampton, page 19 of your agenda.
Are you Ms. Schultz?
I'm the
Daughter? Sorry to keep you waiting.
That's okay. I was running late anyway, but I was all the way to Inverness. I didn't realize it was you.
Oh, no.
Yeah. I was like, man, I only had a 10-minute drive. I went an extra 20.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And your name, please?
Anna Wilkie.
Good morning still.
Good morning.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 215-8326, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6759 West Sasser Street, Homosassa, Florida. Property owner Dolores M. Schultz. Have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection, February 3rd, 2022. Photos I took during my corrective action inspection, March 31st, 2022. Photos I took during my final inspection, April 19th, 2022. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, a picture of the notice of hearing posted at the property, and a copy of the posting affidavit completed on April 6th, 2022.
Well, ma'am, I guess I'd just like to ask you to take a look at these and let me know if you have any issue with them. Do you have a power of attorney for your mother?
Yeah, the state of New York.
I'm sorry?
The state of New York.
In the state of New York? It's a state of New York power of attorney? Okay.
Yeah,
that's fine.
because she wouldn't give it to me, remember? She wasn't in the right state of mind at that point. Now she's regretting it.
So you're saying there is no power of attorney?
The state of New York has the power of attorney over her.
Oh, is there a guardianship or something?
Yeah, they have guardianship of all her finances, and my brother has guardianship of her medical.
Okay.
Because they're all there.
All right.
I don't contest any of that.
Do you live on the property?
Yes.
Okay.
It's a, yeah, we won't get into
That's
that.
what I needed to understand.
Yeah,
just
no, I live there. Yeah,
I needed to understand that so that I could understand your standing to
yeah,
present
'cause I
today.
live there.
Okay.
Yes. I mean, we are cleaning it up. We have taken a lot out. Where he's still taking stuff out now.
And if I may just ask you to wait so that the assistant county attorney can hear what you have to say. She's looking through the exhibits. Okay. Is there anyone else from the public who wishes to be heard on this case? I see and hear no response. What's been proposed as exhibits A and B, I believe, are evidence.
Yes, sir.
Thank you.
Like the photograph of like the trailer with the tires and stuff, that's all coming off of it.
Okay.
We also have sanitation that comes out every 2 weeks. Sanitation department or whatever they are, or I don't know what the other department is.
Health department?
Yeah, they come out every 2 weeks just to see how we're doing. So he actually walks through the yard and sees it all. That's
Okay.
where all the tires are coming from.
Okay, well, it's.
So, I mean, we are taking a lot out.
I gotcha. Well, Mr. Hampton, please proceed.
I conducted my initial inspection on February 3rd, 2022, and I observed the property to be in violation of the ordinance listed above. There was scrap metal, auto parts, household garbage, and other miscellaneous junk and debris. The notice of violation was issued February 3rd, 2022. Shortly before the corrective action inspection, I was checking another property we had case on and ran into a David Foreman. He advised me that he lived at the address listed above and that he was aware of the violation. He said he had been hired by the property owner at the property he was at to finish cleaning up from their demolition. I had told Mr. Foreman that his corrective action date was in 2 days. He said he understood. I told him that I would give him a few more weeks to show a lot of progress towards cleanup since the job that he was currently doing over there. He said he definitely would. I conducted a corrective action inspection on March 31st, 2022. The only progress that appeared to have been made was more junk had been added and also moved around. Notice of hearing was issued on March 31st, 2022. I've had not had any further contact with anyone regarding this property. I posted the property with the notice of hearing April 6, 2022, and as of my final inspection, April 19, 2022, I have only noticed things being moved around and some things loaded on trailers prepped to be removed.
Okay. So, Ms. Wilkie, is it?
Yes.
What's going on the property?
We actually have removed a lot out because we've been taking from the front and the back. I mean, I didn't bring them, but I do have receipts from the landfill and everything showing where we've taken stuff out. And that's what he's doing right now, too.
How many people are living on the property?
There was 4, and then my one daughter just moved back in.
Okay.
So.
And
then, I mean, we've been going day and night trying to get it loaded up at night, and then he takes it during the day. Because with having the health department also, that included more than what he had seen.
Can you explain to me what's going on with the health department?
The same person that contacted, I don't know if he was contacted or not, but the person is, we have a lady that gets everybody in the neighborhood. She called, so they had to come out, and we had a lot of tires and stuff, so we're trying to make him happy and them happy at the same time, so we're pulling from the back too.
There's an
trying to get
unofficial, there's a resident who's an unofficial member of code enforcement.
Yes.
Calling, okay.
Yeah, so so not just trying to get what he does see, we're trying to get everything that they're seeing also, you know, and there was a lot.
But I don't understand why the health department's coming out.
Because of the tires. It's a mosquito.
Oh, okay.
Mosquitoes.
Okay.
Yeah, so we have to get the tires out.
Yeah. Does the county have a program for that? Because that's interesting.
They do like pickup sometime. Like
Yeah.
the landfill will do like free pickup
Wow.
sometime.
They don't do very much anymore.
Yeah,
It's so
for a
much
while
in-
there, they were doing 2 a year,
Yeah,
actually.
That's
We're
interesting.
not even
Okay.
doing that.
Residential properties could take up to a certain amount of
Yeah.
tires for free.
Yeah, and they don't.
Not
really-
pickup,
it
but
doesn't really
for them to
do
drop off
much.
for free.
That makes sense. Okay.
So, but no, we are, it may not seem like Tim from where he sees, but we have made a lot of progress.
Ma'am, how much time do you need to fix it?
I would say 30 days, but.
Did you
to
say
be-
3?
I said, I would say 30 days, but to be safe, I would say give me 2 months just because we have our jobs also, you know.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requested the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
Ma'am, how are you getting rid of the stuff on the property?
Taking it to the landfill.
In a pickup truck, in a trailer?
Between the pickup truck and a trailer hooked to it. That's why the tires get on the trailer and stuff, so.
Okay. All right, I'm going to find the property in violation. I'll adopt the county's proposed findings of fact and grant you, as you requested, 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Schultz. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Okay. No, I will definitely take care of them. I mean, they're still taking stuff out right now because I just messaged them to tell them I was still here. They're like,
All right.
we're still moving and stuff. But I'm like, okay.
Good luck.
So, thank you.
Thank you.
Thank you.
Next case, Brenda J. Graves and Angelica B. Hart, case number 215567, Code Officer George Pearson, page 10 of your agenda.
Are you ready?
I am.
My name is George, for the record, my name is George Pierce. I'm a Citrus County Code Compliance Officer. Case number is 215567. Violation is junkyard conditions, a violation of Citrus County Ordinance, Chapter 20, Article 3, Section 20-31A. The address is 10242 East Pike Drive, Inverness, Florida, 34450. Property owners are Brenda J. Graves and Angelica B. Hart. The service was good through posting the property and posting of the copy of the notice of hearing and the bulletin board at the Lecanto Government Center dedicated to such postings. I would like to authenticate and request the following be entered into evidence. Exhibit A, photographs that I took on December 8, 2021. The photographs depict the violation of junkyard conditions. Exhibit B, copies of notice of violation, notice of hearing, and affidavit of posting. Exhibit C, I took photographs on April 19, 2022. The photographs depict the property to still be in violation of junkyard conditions.
Is there anyone from the public who wishes to be heard on this case? What's been proposed as Exhibits A and B? Is there a C?
You always a C.
Not with you, yes, actually.
Yeah, with
so,
me,
yeah,
because I'm
you're
a
right.
girl.
The others,
I do it the old school way.
I was gonna say the others got rid of that.
Always a C.
But you've kept the C.
I don't know where these guys got up with just doing A and B.
When I started doing this, it seemed like everyone had the C, and it's changed. So
No, it's because you got lazy.
you're keeping the dream alive.
I'm keeping the
Yeah.
dream alive as long as I'm there.
The dream of Exhibit C. Exhibits A, B, and C are evidence.
Yes. C is the final inspection.
Yep.
Is that a truck tire? That's a big tire.
I just see the B clip to A there.
Here is C.
Okay. That's key.
And, you know, you can't, don't be so critical. I'm not saying, I'm not being critical against the lazy guys for doing this.
Oh, yeah.
But,
Well, you have different styles, and that's okay.
if they did it right, they do it my way.
You put them on notice.
Okay.
All right.
I conducted an inspection on December 8, 2021. I observed a violation of junkyard condition. The property had junk and debris, 3 tires and miscellaneous junk and debris. A notice of violation was issued on February 4, 2022. A notice of hearing was issued on March 8, 2021. I'm sorry, on March 8, 2022. I spoke with a female subject who advised she was a tenant and physically unable to clean up the property. She was asked to notify the property owners of the problem. She asked to put me in, I asked to put her in touch with the property owners, which she has failed to do. A final inspection was conducted on April 19, 2022, and the violation of junkyard conditions still exists. I have a phone number for the property owners, and I've called several times and left detailed messages. and I've yet to receive a phone call back.
All right, what's the county's recommendation?
The Citrus County Code of Compliance Division respectfully respects that its special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owners once they were advised of the violation. The amount is appropriate given the severity of the violation and the respondent's action relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for final reinspection.
What was the fine amount?
$50.
Yeah. All right, I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, Mr. Wall.
Thank you.
Next case, Wilma B. Benefield. Case number 278988. Code Officer Matthew Hampton, page 4 of your agenda.
Good afternoon now.
Yes.
It's case number 278988, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of Citrus County Code of Ordinances. The address is 6645 South Frankfurter Way, Homosassa, Florida. Property owner Wilma B. Benefield. Have good service via signed certified mail return receipt. I would like to authenticate the documents requested to be admitted into evidence. Photos I took during my initial inspection February 21st, 2022. Photos I took for corrective action inspection March 23rd, 2022, and photos I took during my final inspection April 19th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no one. What's been proposed as exhibits A and B are evidence. Thank you.
I conducted my initial inspection on February 21st, 2022, observed the property to be in violation of the ordinance listed above. As household garbage, scrap metal, tree debris, miscellaneous junk, and debris, auto parts, and other debris around. I've had no contact with anyone regarding this violation. I conducted a corrective action inspection March 23rd, 2022. There was little to no progress that had been made. Notice a hearing was issued March 23rd, 2022. I received good service via signed certified mail return receipt signed for March 26, 2022. Name is mostly illegible. As of my final inspection April 19, 2022, there was still has been little to no attempt to come into compliance, and there is still tree debris, trash, auto parts, tires, and other miscellaneous junk around the property.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection. I have to work on my inflection.
I think I'm looking at the wrong page in the agenda, so.
We're on page 4.
Yeah, I was looking at the wrong one. Okay, All right, the property is found to be in violation. I adopt the county's proposed findings of fact. The property owner is granted 60 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Benefield. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Ms. Benefield shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Yeah, thank you.
Next case, Teresa L. Cummings, case number 216-0423. Code Officer Amy Becker, page 7 of your agenda.
I really thought we were further along in the agenda.
We're getting there.
It's this due process thing where we've got to...
Let's get caught up on it.
Not everyone does, but yep, that's the blessing and curse. Thank you.
Amy Becker, Co-Compliance Officer. This is case number 216-0423, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner was previously adjudicated guilty of the same violation at the same location on September 15th, 2021, case number 2144298. The violation abated on November 2nd, 2021. Fines total $1,059.43. The address is 9155 North Carissa Way, Citrus Springs, Florida, and the property owner is Teresa L. Cummings. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on March 11th. Photos taken on March 15th showing the posting of the property, and subsequent inspections on March 18th, April 1st, April 5th, April 8th, April 12th, and April 14th, and my final inspection on April 19th. Exhibit B, a copy of the administrative complaint and notice of hearing for the repeat violation, and a copy of the posting affidavit. Exhibit C, a copy of the findings of fact and the order acknowledging compliance for the previous violation.
Is there anyone from the public who wishes to be heard in this case? Let the record reflect that there is none or no one, and what's been proposed as Exhibits A, B, and C are evidence.
On March 11th, I conducted my initial inspection for accumulation of junk and debris and observed trash on the front yard, discarded furniture, which is a clear violation of the ordinance listed above. As of my final inspection on April 20th, the property remains in violation. I have had contact with the property owner and she is aware of the violation.
Your final inspection was the 19th, not the 20th.
Yeah, excuse me, change the record. My final inspection was April 19th. Thank you.
Have you noticed improvement?
It's changing. No, I have not, because it changes. She takes more out and then she brings more back.
When you talked to the owner about this, what did she say?
She says that she's going to clean it up. And then she said, I talked to her yesterday, and I reminded her about the hearing today, and I was told she has no phone. I was told she has no transportation, and I was told now she's going to have a garage sale.
In the prior case, case number 2144298, I had granted 30 days to fix it in an order issued on September 16th, 2021, and an order acknowledging compliance issued on November 3rd, 2021. Do you remember if you re-inspected immediately after 30 days or if you granted more time for compliance?
On the first case, you mean?
Mm-hmm.
She came into compliance.
Within the 30 days?
The violation abated on November 2nd, 2021, as far as the first case. So I did not go back out until I got.
I see.
Until
okay.
I was told to go back
Got
out.
it. Okay.
After the time had lapsed.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day, along with administrative costs, to begin on March 15th, 2022, and continue until April 19th, 2022. That would be 36 days at $150, totaling $5,400, and a fine of $200 per day from this day forward until the violation is abated. We would also ask that the Special Master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated, so that we may re-inspect the property.
The property is found to be in violation again, and a fine shall be assessed at $150 per day from the dates of March 15th through April 19th, 2022, 36 days, for a total fine of $5,400. There shall be a fine of $200 per day from today until the until the violation is abated. This fine will be recorded and will constitute a lien on the real or personal property of Ms. Cummings. The County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Next case, David Donovan and Belinda Donovan, case number 215-8042, Code Officer Matthew Hampton, page 8 of your agenda.
Good afternoon again.
Good afternoon.
Case number 215-8042, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 5550 South Glen Acres Terrace, Homosassa, Florida. Property owners David and Belinda Donovan. Have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection, January 31st, 2022. Photos I took during my corrective action inspection, March 7th, 2022. And photos I took during my final inspection, April 19th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a picture of the posting of the notice of hearing at the property, and a copy of the posting affidavit completed April 6th, 2022.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no one.
So if you need a recliner.
Thank you.
Did you say they were accepted, sir?
Yes, what's been proposed as exhibits A and B are evidence.
Thank you, sir.
I was actually thinking about the number 1729 when you brought that up, and a lot of people don't know that 1729 is the smallest number that can be written as the sum of 2 cubes in 2 different ways. 1 cubed plus 12 cubed, and 10 cubed plus 9 cubed.
I don't understand anything.
But I was just thinking about that, and so I apologize.
That's all right.
Sometimes those thoughts get you.
I conducted my initial inspection January 31st, 2022. and I observe the property to be in violation of the ordinance listed above. Household garbage, scrap metal, furniture, miscellaneous junk and debris spread around the property. I've had no contact with anyone regarding this violation. I conducted a corrective action inspection March 7, 2022. There was some progress with the large pile of garbage at the end of the driveway that had been disposed of, but there was no change to the rest of the property. Notice of hearing was issued March 7, 2022. I posted the property with the notice of hearing on April 6, 2022, and as of my final inspection, April 19, 2022, there still has been little to no other effort to come into compliance. There appears to actually be more furniture and debris added near the front door.
Did you have contact with the owner?
No, sir.
No. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The property owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Donovans. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record.
Thank you.
Next case, Christopher J. Trapuzano, case number 212-6656, Code Officer Alan Jonason, page 20 of your agenda.
Good afternoon.
Good afternoon.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 212-6656. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. Address of the violation is 1266 North Arkansas Terrace, Hernando, Florida. Property owner is Trapuzano Christopher J. I have good service via posting on the property and at the Lecanto Government Building. Would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during initial inspection on 1 February 2022. Compliance inspection on 3 March 2022 and my final inspection conducted on 19 April 2022. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, posting affidavit, and a copy of the photo of the notice of hearing posted on the property.
Is there anyone from the public who wishes to be heard in this case? Let the record reflect that there is none, and what's been proposed as exhibits A and B are evidence.
On 1 February 2022, I conducted my initial inspection and observed the property was overgrown. A measuring stick was used as a reference to show that the grass or weeds exceeded 18 inches, which is a clear violation of the ordinance listed above. On 1 February 2022, a notice of violation was issued for excessive growth and accumulation of vegetation. On 3 March 2022, I conducted a compliance inspection and observed no change to the property. As of my final inspection on 19 April 2022, the property remains in violation.
Is the overgrowth what would be considered brush?
It's
it's not grass.
It's grass, weeds. Further back, I mean, the pictures are from the front, but it's very overgrown.
Okay, so you're saying there's grass as well?
Yeah.
Okay.
Just excessive vegetation.
I don't think this would be an accumulation of vegetative matter.
No.
But it looks like, I do see that there is some grass that's over the 18 inches. I just want to make sure that it looks, that the majority, the bulk of the violation, I think in your case, is what appears to be brush, but I'm not sure. Is it, because if it's bushes...
Well, it's growth of whatever is there. I mean, I can't break down what every species of plant is there, but it's definitely overgrown, whether it's grass, weeds, brush, debris. It is excessive growth.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner, how big is this parcel? Do you know?
It's less than an acre.
Okay. The property owner is granted 60 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Mr. Trapezzano. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Trapezzano shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Yep.
Next case, George Huffert, case number 216-1294, Code Officer Matthew Hampton, page 11 of your agenda.
Good afternoon.
Good afternoon.
Matt Hampton, Citrus County Code Compliance Officers, case number 216-1294. It's an abandoned, unserviceable, and unlicensed vehicles, a violation of Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. This is a repeat violation. The property owner had been previously found guilty of the same violation on the same property. It's case number 236129 on December 19, 2018. The property came into compliance on January 24, 2019. No fines were accrued. The address is 6301 West Beaumont Lane, Homosassa, Florida. Property owner is George Huffert. I have good service via posting of the property as well as Lecanto Government Building and signed certified mail return receipt. I would like to enter and authenticate this evidence I would like to authenticate this one's messed up. I would like to enter and authenticate the following into evidence. Exhibit A, photos taken during my initial inspection, March 28, 2022. Exhibit B is photos taken on my subsequent inspections, March 30th, April 4th, April 12th of 2022, and my final inspection of April 19th, 2022. Exhibit C will be findings of fact and order acknowledging compliance for case number 236129. And Exhibit D is a copy of the administrative complaint notice of hearing of a repeat violation, a picture of the notice of hearing posted at the property, a copy of the affidavit of posting completed March 30th, 2022, and a copy of the signed certified mail return receipt signed for by Mr. G. Huffert on April 1st, 2022 at 2:40 p.m.
So is it A, B, and C?
A, B, C, and D.
And D, okay.
Yes, sir.
What's been proposed as exhibits A, B, C, and D are evidence. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is none. Thank you.
Yes, sir. I conducted my initial inspection on March 28, 2022 and observed an SUV with flat tires and a smaller vehicle that appeared to have flat tires as well. I spoke to the property owner, Mr. Huffert, at the property. I advised him of the violation, and I also advised him that this was a repeat violation and the fines would begin to accrue that day. He claimed that they were both tagged, but he would not allow me to look. I advised the vehicles had to be operable as well, and with flat tires, that made them inoperable. That's when he told me the small vehicle was due to be picked up because it did not work. I issued the repeat violation and posted the administrative hearing, notice of hearing at the property on March 30th, 2022. And subsequent inspections on March 30th, April 4th, April 12th, 2022. The property remains in violation. There's been no change. I did speak with, during one of those inspections, I did speak with Mr. Hufford, and he got rather agitated. Didn't know why I was there bothering him. The smaller vehicle, during those inspections, the smaller vehicle remained and had never been removed. I advised him that the property remained in violation at our last discussion, and advised him of the hearing date. As of my final inspection, April 19th, there had been no change.
What is the county's proposed findings and
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day, along with the administrative cost, to begin on March 28th, 2022, and continue till April 19th, 2022. That would be 23 days at $115 a day, totaling $3,450, and a fine of $250 per day from this day forward until the violation is abated. We would also ask that the Special Master find that it is a respondent's responsibility to notify the Code Compliance Division when the violation is abated in order to allow for reinspection.
And that total fine was $3,450?
Yes, sir.
Okay. I adopt the county's proposed findings of fact and law. The property is found to be in violation again. A fine will be assessed of $150 per day, running from March 28th through April 19th, a period of 23 days for a total cost of $3,450. That fine will be elevated to $250 from today's date forward until the violation is abated. The fine will be recorded and will constantly lien on the real or personal property of Mr. Hufford. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Hufford shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Next case, United States of America. Case number 216-0481. Code Officer Amy Becker, page 24 of your agenda.
We were wondering if the United States of America was going to come to the hearing today.
I wonder if we have jurisdiction over the United States of America, but I'm interested to see what's going on.
Amy Becker, Code Compliance Officer. This is case number 216-0481, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 409 West Oberlin Place, Citrus Springs, Florida. The property owner is the United States of America. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on March 15th, 2022. Photos taken on April 1st at my corrective action inspection. Photos taken on April 7th showing the posting of the property, and photos taken on my final inspection on April 19th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Is there anyone from the public who wishes to be heard on this? Without objection, what's been proposed as Exhibits A and B are evidence?
On March 15th, I conducted my initial inspection for accumulation of junk and debris and observed furniture and appliance, piles of vegetative matter, and wood debris, which is a clear violation of the ordinance listed above. As of my final inspection on April 19th, the front's clear, however, the debris is on the side and the back that remains. I have had contact with the tenant. She's aware of the violation.
Can you explain to me how the United States of America owns this property?
Well, I can show you a copy of the deed.
Was it HUD? I mean,
It's the United States of America acting through a Rural Housing Service or successor agency of the United States Department of Agriculture.
doing some research here.
Let me see if I have.
I'm not aware of anything in the code that exempts the United States of America or any of its agencies from complying with the Citrus County Code, but I don't want to issue an illegal order against the federal government. There was a war fought over some of this stuff 150 years ago. So,
Yes, they just acquired it from the clerk.
oh, really? Okay.
Yeah, and I think it's because they foreclosed on their, and they bought it at the foreclosure sale. That's what I believe.
Is that a recent purchase?
The certificate of title was dated January 19th, 2022.
Okay.
And it was in the case of the United States of America acting through Rural Housing Service versus the clerk, Kimberly Gardner, unknown spouse, Citrus Springs Civic Association. Get the case number. It's 2019 CA 783, which I believe was a foreclosure proceeding.
It could be that I have jurisdiction to issue the order, but that it may not be enforceable. This is the case where there is sovereign immunity between government agencies. So, for example, there's case law in Florida where a school board was found to be liable to pay stormwater dues to the city of Ocala, but when the city of Ocala sued the school board for payment, it failed due to sovereign immunity claims. And I know it worked its way up into appeals. I don't know if it was ultimately resolved. But this is a little different because it's the federal government. Does the county believe that it has the ability to fine and foreclose on the United States of America? I mean, I don't know. Because I'll tell you, if I don't...
I'm going to refer to my attorney.
Oh, thank you so much. Oh, I'm sure we do, but it would be a matter of would we?
Okay, so...
I mean, the United States government can be sued.
It can be
and
sued.
It can have property that can be foreclosed on.
Can
for
it?
debts.
Can it?
I would think.
Yeah, see, I don't know.
I'm looking at it from the point of view of people who have other countries that have loaned money to the government, because I do hear that every once in a while you'll hear in the news that they might call in the debts, and so how would they enforce
For
the
other
debt?
governments? Well, I don't think anyone
I'm talking
cares what
about-
happens to Venezuela's property holdings in Florida. I mean, I know there are attorneys in Miami, but I don't think anyone argues what could be done to them. I think I hate to do this. I'm going to continue this to the next hearing, just so that
We can all do our research.
Yeah. So I'm not going to issue a formal brief or order on this, but I think we need to be able to understand what our jurisdiction is here. So
Thank you.
I'll continue that one. Thanks.
The last two cases, Thomas L. Turner, case number 215-9146, and case number 215-9168, Code Officer J.C. Charlton, pages 21 and 22 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer. Case numbers 215-9146, 215-9168, accumulation of junk and debris, Chapter 20, Article 3, Section 20-31A, and unlicensed and inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41, the Citrus County Code of Ordinances. The address is 6263 West Soul Lane, Denellen, Florida. Property owner Thomas L. Turner. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on February 17th of 2022, follow-up inspection on March 3rd, corrective action inspection on March 21st, and my final inspections on April 19th of 2022 for both cases. The notices of violation, notices of hearing, photos of the posted property, and copy of the posting affidavits for both for both cases, excuse me.
So are these, is it one set of documents for both cases? Or are you two identical sets of exhibits?
They're going to be two identical.
Okay, perfect. Is there anyone from the public who wishes to be heard on this case? Let the record reflect that my audience has abandoned me. And what's been proposed as exhibits A and B in each case are evidence. Thank you.
An inspection was conducted on February 17th of 2022. I observed tree debris, broken household furniture, discarded auto parts, appliances, and debris throughout the property. I also observed a violation for unlicensed and inoperable vehicles on the property as well. I spoke with the tenant at the property and explained the violation. She stated she would try to remove it. I've noticed a roll-off dumpster was brought onto the property, and some of the items were removed in the front yard. However, throughout the property, junk and debris remains. I also observed that one of the vehicles was removed from the property, the yellow inoperable vehicle towards the back of the property, but that was just put on another property. As of my final inspection on April 19th of 2022, the property remains in violation of both accumulation of junk and debris and unlicensed and inoperable vehicles.
What is the county's recommendation in each case?
Due to this being the third case for junk and debris and the second case for unlicensed and inoperable vehicles on the property, the Citrus County Code Compliance Division respectfully requests that Special Master assess a fine of $200 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation respondent's actions relative to this violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
To be clear, you're not seeking a fine for past violations. You're seeking just a fine going forward.
Correct.
Okay. The property is found to be in violation in each case. I adopt the county's proposed findings of fact. All right, I'll grant 90 days in each case from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed, and that goes for each case. This fine will be recorded and will constitute a lien on the real or personal property of Thomas Turner. The County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Is that the last hearing?
That's it.
Okay, the time is 12:45 p.m. This hearing is adjourned. Oh.
Look what I did.
You know, the funniest thing was I was walking behind somebody the other day, and they were talking about Bruce Willis, and one of them said, "That's the best Christmas movie I've ever seen." And I wanted to say, "Excuse me, excuse me."
I wish I had.
It's not really a
I wish I had seen that before I adjourned the hearing, because looks like someone got the last laugh. But we'll see. We'll see.